79, my lord.
Yes.
May I read, my lord?
Yes, sir.
Whoever intending to insult a modesty of woman utters any words, makes any sound or a gesture, exhibits any object in any form, intending that such word or a sound shall be heard, or that such gesture or object shall be seen by such woman, or intrudes upon privacy of such woman, shall be punished.
So according to you, she has not heard, she has not seen.
My lord, she was in custody. It is not the case of the complainant. That, my lords, in the custody, she had access to these statements. Therefore, my lords, she instructed her to file the complaint. That is not there.
So is it the statement of the complainant that she was instructed as a power of attorney?
No, my lord, nothing.
No.
No. Absolutely. She says that she is a caretaker and a family member. Therefore, she wants to file this complaint.
Yes, you want to say anything?
Yes, Minister, I do have my submissions to make. There are two things, Minister. Whatever was spoken was not as if his statement was misinterpreted. If the court were to assume his statements were in fact misinterpreted, what statement he made in the press media is about 30-40 seconds. The moment I play that to this honorable court, this honorable court would be able to come to a conclusion whether his statements were misinterpreted or whether those statements were made with an intent to outrage my modesty. That is one aspect. The second aspect is, my lords, he says that such statements, whatever he's made, should be either heard or should be seen by the victim herself. Only then a complaint can be made is what the alleged contention is. To that, the statements that he has made is not just published in the media channels. It's also published. It's also printed in the newspaper articles. These newspaper articles were available everywhere, including the jail authorities. And I will produce as to what it is, because he produces only one newspaper article where he says, I wanted to only expose 2 ministers who were part of all these things. If he were to expose 2 ministers, he could name 2 ministers, that is the only thing. But making statements to outrage the modesty, in simple terms, if I were to rephrase what he has stated in the media, he stated, yes, I am being investigated. DRI has registered a case against me. I am in judicial custody. All those facts are, as he said, it's undisputed. But to say something which is not part of investigation, to something to say which outrages the modesty, he says, I have hit the gold in all the holes of mine, is what he says. This is not once, he repeats this statement twice. With the kind permission of the court, it's a 30-second video. I will just play it for this honorable court. If the intention was to outrage the modesty of women, or was the intention to expose 2 ministers or to expose some loopholes in the law? He's a sitting MLA. There should be some responsibility. You are making statements out in the public. And these kind of statements would just would bring the moral of anybody down. I will just say with the kind permission of the court.
He has extracted allegations in page, of course.
I will just play it because this honorable, because his contention is his statements were misinterpreted by the public, by the media. If it was misinterpreted by the media, let's accept it, my lords. If it is not, this honorable court shall not grant him an interim order because that would send the wrong message. May I play it, my lords, to your lordships?
But
it's just a 30-second.
Only I would submit this. The one of the ingredient is that whether the victim has, it is in the complaint, my lords, which is a document which has to be seen. In the complaint, if there is any line to show that the victim has seen it and she has instructed the caretaker or a family member, whatever they may call, then, my lords, yes.
Read the complaint.
My lords, I'll point out. My lord,
1 minute.
My lord, the paragraph 1, page 12. My name is so-and-so. I am a family and relative and caretaker of so-and-so, a renowned, accomplished actress who has established a career in so-and-so. My lord, this paragraph 1, my lord, gives the background of the this thing. Secondly, my lords, para 2 speaks about the DRI case being investigated her. Then para 3, my lords, while investigation concerning the aforesaid matter is still underway, a deeply distressing, unfortunate incident occurred on 17/3, the day after I make a statement on the floor of the assembly, has resulted in immense emotional trauma and public humiliation to so-and-so. And during press conference held on 17/3, so-and-so, sitting member of parliament, assembly, has made a statement, my lord, they extracted the complaint. Then please come to para 4. The above statement made by so-and-so with the malicious and indirect attacking of modesty and dignity of Harshavardhan so-and-so. Statement of Basangode Yatnal carried a clear insinuations aimed against casting aspirations. Furthermore, derogatory nature of aforesaid remarks has resulted in tarnishing the image of. Then it goes on to para 6. Moreover, the attack on the modesty of so-and-so is aggravated by the fact that remarks were made by Basangoda Patil Yatnal in the public forum so-and-so. Para 7. Vulgarity and all those allegations are made against me. Then comes para 8. Where is the statement that the lady has seen it in the custody of the jail where the new public papers were available to her to read the entire day-to-day news, or the video or a TV? Is he trying to say that she was provided with the facility of television in the jail? Or she has no connection to the incident?
Yes.
That is 1 minute. Second is, minutes, whether I have heard or not heard, can it be a subject matter of a 482 right now? Minutes, matter is at the stage of investigation. If investigation reveals that I have heard this statement, yes, my complaint is maintainable, because a family member can very well maintain the complaint. Minutes, as held by the Honorable Supreme Court in A.R. Anthule's case. A family member can also file a complaint. The question whether I have heard it or not is a matter of investigation which will reveal. At the stage of 482, for us to rule out the fact that she has not seen the newspapers or not read about what the remark was made against her is not at this stage, minutes. May I present the newspaper articles which were circulated, minutes, that would throw light on as to what has happened? Because jail is not privy to newspapers, minutes. Newspapers are available in the prison. The lordships may see, they very cleverly produce only one statement where he makes only allegations against ministers. All news, in fact, newspaper print media says the comment is vulgar.
But we can't
Not
go
every
by
print
the
media cannot be.
we can't go by the media statements of what
Then
they
we
call
will.
it. at
Then
all.
we will read the. When we will. Then I will just present this honorable
pass on
court as
this
to what he
judgment.
has made, minutes. May I pass it on, minutes?
But you can't judge me on the
It
moral
just-
standards. If they make out a case, yes.
Yes, I have made out a case, minutes. I will play the video what he has played.
Please see the
Let
Supreme
this
Court.
honorable court let your lordships decide whether the comment was made with the intent to outrage the modesty of mine, or whether, as he says, his comment was misinterpreted by the media. I will leave it to the discretion of this honorable court. Making such comments, being a sitting MLA holding a responsible constitutional post, my lords, it's not welcome, my lords. In fact, in page number 14 of the petition itself, whatever he has spoken is in fact extracted, my lords. The video will throw a clear light on it.
But the apex court at para 11 of the judgment. What is to be seen is the complaint. My lord, I don't have to be judged on a moral standards. If they make out the ingredients of the offense in the complaint which are prima facie absent, then apex court says question of continuation will not arise. Please come to para 11, page 14 of the judgment.
Yes.
In the contextual situation, it is also relevant to refer to the decision of this court in Mohammed Wajid versus another state of UP, where this court, insofar as it is relevant, held thus: it will not be just enough for the court to look into the averments made in the FIR or complaint alone for the purpose of ascertaining whether necessary ingredients to constitute the alleged offence are disclosed or not. In a frivolous and vexatious proceedings, court owes a duty to look into many other attending circumstances emerging from the record of the case, over and above the averments, and if need be, the due care and circumstantiation, try to read in between the lines. Court, while exercising a jurisdiction under 482 CRPC or under 226, did not restrict itself only to the stage of the case, but empowered to take into account all overall circumstances leading to initiation, registration of the case, as well as the material collected. So now, my lord, on the face of it, it is nobody's case that the Kumari Harshavardhani, my lords, has seen or pursue this video. So where is the question of continuation, my lords? It's a politically motivated. Seeing a video will not change the complaint contents.
Minutes, there is a judgment of the honorable coordinate bench, minutes. May I present that, minutes?
The language used in the complaint may not.
Sir.
Page number 27 of the said judgment produced by my learned friend, my lords, does not cover an offence under section either 509 of IPC or 79 of BNS. It's a principle laid in 406, 420 of IPC, my lords. That principle may not be applicable to this case. Having said that, my lords, in the judgment what I have produced before this honorable court, page number 27, paragraph 14, my lords. Page number 20, the last page, my lords. This is a clear case dealing with section 509, which is equivalent to 79 of BNS. May I read, my lords?
Where are you reading?
Para 14, my lords, para 14. Para 14, page number 27 of the judgment. In the matter of Ala Baksha Patil versus A.B. Patil, rendered by the coordinate bench of this Honorable Justice M. Nagprasan.
Yes. Where you are reading page 27?
Para 14, my lords, of the
Page
judgment.
27, where
Page
you want to-
27, my lords. Therefore,
Yes.
therefore, any sanctological or salacious statements made against a woman, either by gesture, writing, speaking, would undoubtedly amount to insulting the modesty of woman. In today's digital age, one need to not physical harm a woman's modesty can be railroaded by sheer circulation of prerogative statements, pictures, or videos in the social media. It is therefore, when such cases are projected before this honorable court seeking quashment, it should not be interfered with but dealt with stern manner. The petitioner has indulged in one such ingredients of such insult by fresco or writing on a wall. Therefore, he cannot get away with making such belittling comments on a woman in public. This is exactly what has happened in this case, my lord.
Page 3. Page 3 of the facts of the case, your lordship.
After he finishes, I'll submit, my lords. I don't want to interfere in.
You completed.
Yes, my lords. My lords, the video, I'll play it for your lordship.
A matter of trial. We'll
It's a
see.
matter of trial, my lords.
Yes.
Lords, page 3. My lord, these are the facts of the case. She began getting unexpected calls at odd hours from various and who is also threatened to life. My lord, when she made inquiries about the phone calls received, it was informed that her mobile number was displayed on the wall of the gents' toilet at Majestic Bus Stand, Bangalore, calling her so and so. Complainant further alleged that some unknown staff to her, being her, had done this, and investigation was to be conducted through a complaint. But completely facts are different. This principle is to be superimposed on the present facts. Nowhere it is applicable.
Heard learned counsel the Venkatesh Dalwai for the petitioner. Learned additional SPP there to take notice for respondent number 1. Learned counsel Shri
Mahesh YL.
Mahesh YL. Undertakes to appear on behalf of respondent number 2, bar complainant. He is permitted registry to show his name in the cost list. Copy of the petition is served on him, which he acknowledges. Given to you, copy?
He has given me no, my lords.
Yes. Learned counsel for the petitioner vehemently contends that the complainant, respondent complainant, claims to be a relative of the person against whom the charges are made by the petitioner accused, which are defamatory and under section 79 of BNS code. Full stop. Learned counsel for the respondent number 2, complainant submits that there are serious charges that are made imputing allegations and tarnishing the image, outraging the modesty of a woman against Srimati Harshavardhini Ranya Rao, who's a renowned, accomplished actress. Therefore, he opposes any interim order in favor of the petitioner. Full stop. Learned counsel for the petitioner takes me through the complaint registered by the complainant, namely Srimati Akula Anuradha, who's a relative of the said Srimati Harshavardhini Ranya Rao. He further submits that the provisions of section 79 BNS would not attract in the present case. However, the matter requires trial. Nevertheless, in the meanwhile, petitioner would be entitled to an interim order. Accordingly, I pass the following. There shall be stay of the further proceedings in crime number 0056 of 25 registered by the High Court PS pending on the file of first ACM,
ECMM.
ACMM, ACJM ಇರ್ಬೇಕು.
Yeah,
EJM.
ACJ. I'm
EJM.
sorry.
Court Bangalore for the offence punishable under section 79 of PNS Bharatiya Nyaya Sanhita 2023 till next date of hearing.
Sought for dispensation.
A date may be fixed, my lord.
Yes. What is this dispensation of?
My lord, dispensation of certified copy of FIR and complaint. I have downloaded it, but I'll produce, my lord, within 2 weeks. I undertake to produce the same.
A1 is allowed 2 weeks time is granted to produce certified copy.
Great.
Date may be fixed.
Solve this matter after 2 weeks and date could have been. No, 28 you can do.
Great.
20.
28.
Obliged.
Suresh. Respondent. Delay of claimant's appeal. I1 of 23 is allowed. Delay of 224 days is condoned. No interest for the delayed period.
Insurance company has also filed MFA 2295 of 22.
All along with MFA
2295
2295 of
22.
22. Yes.
My lord, in this case,
A2 of 23 is allowed. Delay of 6 days in filing the appeal is condoned.
it may be connected with KSRTC appeal, my lord. 11814 of 23, my lord.
All along with MFA. This next week.
Much obliged.
Next,
For appellant, my lord.
Yes,
Delay of
one of
151.
And for the respondent, my lord,
151 days delay condoned.
without interest.
ಅಲ್ಲ ಇದು ಅವರಿಲ್ಲ ಮೇಲೆ
ನಾನಿದ್ದೀನಿ R2.
ECA ಅಲ್ಲ ವಿಜಯ್ ಕುಮಾರ್ ಇದಾರ.
Yes, my lord, I am for respondent number 2.
Your claimant ಅಲ್ಲ.
ಎಸ್ ಮೇಡಮ್ ಕ್ಲೈಮೆಂಟ್
Yes. I1 2 of 23 is allowed. Delay of 312 days is condoned. No interest for delayed period.
Can you list along with another 5 matters, connected matters?
Call along with.
Told.
ಯಾವುದು ಸತೀಶ?
We have filed an IO for paper publication, my lords. For
IA.
respondent 1 and 3, my lords. Kranti Deepa, my lords, Shumaga edition.
Which newspaper?
Kranti Deepa, my lords, Shumaga
Right.
edition.
All right. The learned counsel for the appellant is permitted to carry out the correction of mentioning the edition of the newspaper in the application. Full stop, next panel. IA1 of 25 is filed to take out notice to R1 and R3 through substitute service by way of newspaper publication in Kranti Deepa of Shumaga edition. As the notice has not been accepted in the regular course, the application deserves to be allowed. Accordingly, it is allowed. Publication shall be taken out in Kranti Deepa Shumaga edition. Taking out publication on or before. Carry out the correction.
Please.
My lord, R1 claimant filed application for withdrawal deposited amount. He supposed 90%.
Yep.
No objection. Entire deposit amount may be released.
Learned counsel for the appellant and counsel for respondent 1 are present. Counsel for respondent number 1 is filed IA. number 1 of 25. Seeking withdrawal of the amount deposited by the appellant before
this honorable.
this court. Satisfied with the reasons assigned. Cause shown, the application is allowed. The respondent number 1 is permitted to withdraw the amount deposited by the appellant before this court. Full stop. The registry is directed to release and disperse the amount in favor of respondent number 1 on production of relevant bank details and particulars.
Amount, my lord, amount may be transferred to the
Way of
criminal.
electronic transfer.
Amount may be transferred to criminal. He is not able to come. Suffering 90% disability, my lord. I already produced a photograph of nature of his suffering.
You hear the order first. Did you hear what I said? Did you hear what I said?
That is
ಏನು
permission to withdraw the deposit.
ಆ ಮುಂದೆ ಏನು ಹೇಳಿದೆ? ಬ್ಯಾಂಕ್ ಡೀಟೇಲ್ಸ್ ಕೊಡಿ ಅವ್ರದ್ದು.
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾರೆ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟರೆ.
ಸರಿ ಸರಿ.
ಅರ್ಥ ಆಯ್ತಾ? ಏನು
ಅಕೌಂಟ್
ಒಂದು ಮೆಮೊ ಅಲ್ಲಿ
Particular.
ಅಕೌಂಟ್ ಡೀಟೇಲ್ಸ್ ಕೊಡಿ ಅವ್ರದ್ದು. The registry will transfer into her name. She need not come upon proper verification.
Matter has been settled before the local adalat. So Kishore has taken the notice. It may be referred to local adalat.
At request matters referred to local adalat. ಯಾರಿದ್ದಾರೆ ಇದರಲ್ಲಿ?
Krishna Kishore. Connected matter ಅಲ್ಲಿ
ನೋಟಿಸ್ ಹೋಗಿರಲಿಲ್ಲ.
ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ ಸರ್, ಬಟ್ ಎರಡು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇತ್ತು. ಅದು
ಇನ್ನೊಂದು ಯಾವುದು?
ಇನ್ನೊಂದು MFA
ಅದು ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಸೆಟ್ಲ್ ಆಗಿದೆ. ಸೇಮ್ ಡೇ ಎರಡು ಆಗಿತ್ತು. ಬಟ್
Learned counsel for the appellant, your claimant
ಕ್ಲೈಮೆಂಟ್
submits that in a connected matter, learned counsel Sri Krishna Kishore had accepted notice for respondent
2. Respondent number 2.
one yaru.
One, it may be displaced the owner.
Respondent number 2. Hence registry to show his name in the cost list. Notice to R1 is dispensed. Memo is accepted.
I'll
At request matters referred to Lok Adalat.
Climate appeal for
Reliance General Insurance,
I will take notice, my lord.
Learned counsel Sri
company also challenging one more appeal. HS Lingaraj appeared for second respondent.
Lingaraja.
Yes, ma'am.
Yes, it's just Lingaraj.
He is for LIC, GIC,
Yes, ma'am.
Reliance.
Reliance Insurance.
HS
Challenge with
Lingaraj.
MF 7950/23, my lord.
Yes, Mr. Lingaraj, you will take notice.
I'll take.
Learned counsel Sri HS Lingaraj is directed to take notice for R2 registry to show his name in the cost list. I.e. 1 of 24 is allowed 56 days delay condoned. Call this matter along with
7950/23.
79 of
23, ma'am.
Lok Adalat.
No, I don't.
Already refer back agide sir, connected matter.
I don't understand.
Call this
Lordship,
matter.
I will call it next week.
Call next week. Nayak. I.e. 1 of 24 allowed 1 day delay condoned list for admission.
Corporation also filed an appeal, my lord. MFA 2910 of 2024, my lord.
Call along with
Lords, this matter appear for the respondent, please, my lord. This matter by mistake along with me was not mentioned in the wakalat, my lords. That may be condoned. He was my colleague. He wanted me to file a wakalat along with him, but unfortunately it was not mentioned as along with me. That's why the officers rightly observed the NOC was not taken from the caveat advocate. I'll produce the necessary affidavit before this court in the due course, my lords. And I sought for release of the amount. Respondent's
I have not
daughter's
received
marriage
the
is
copy of the
in
IA.
May.
I have not received the copy of the
you
IA.
have filed wakalat.
I filed a wakalat, my lords, but in the wakalat, earlier counsels along with me is not mentioned. He has not given NOC, but he was my colleague. Intent was to appear along with him. He is basically a trial advocate, my lords.
Where is he? When obtain it, I'll grant you a week's time.
Yes, urgency is there, my lord. Tomorrow, day after tomorrow, my lords. I will file tomorrow only.
Okay.
I've not received the copy of the IA.
I send it through WhatsApp. In fact, the senior is not receiving the phone. I send it through the mail also. I'll cover the copy.
Once again, Kalsi, Mr. Gangadhar.
WhatsApp al ಕಳಿಸ್ತೀನಿ sir.
Yes, yes, please.
Call this matter.
PDF file ಕಳಿಸ್ಕೊಡಿ.
Third.
Oblige.
Release of amount not pressed.
I appeal for the appellant. There is a delay of 18 days in filing the appeal.
Could you order dated 26/11/24?
But he was permitted to withdraw the amount on deposit.
IA 1 of 25 is dismissed as not pressed. IA 1 of 24 is allowed. Delay of 18 days in filing the appeal is condoned.
Records may be secured. Records may be secured.
Secure records.
Please.
Rangegowda, issue notice on main and IA.
For the appeal by the corporation, case of injury.
Notice to respondents pending consideration of IA for delay, IA for stays taken. Stay of the order, operation execution of the order dated 27/8/24, MVC 990 of 22. Passed by Principal Senior Civil Judge, ACJM, Additional MACT, Puttur DK, subject to the appellant depositing 50% of the award amount within 4 weeks from today before the tribunal.
Before the tribunal.
Same order.
Aye.
Order dated 7/8/24, MVC 1695 of 22. Now court, Mysore.
Mysore.
Principal Small Causes and Senior Civil Judge and MACT at Mysore, subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from today. On such deposit, the amount shall be kept in FD, a nationalized bank. In death case,
Death case.
Huh?
Death case.
Injury hakidare?
Death case.
31. All right. So you have any objection in withdrawing?
Both murder.
We'll permit them to withdraw. It's a case of death.
Yes, ma'am.
Full stop. Upon deposit, the respondent, claimant, will be permitted to withdraw the amount. It shall be released upon production of bank details and other particulars upon proper verification.
In terms of award.
Other, in terms of the order. Issue notice. Same delay. IA for stay. Dated 27/9/24. MVC 1853 of 19. 5th Additional District Sessions Judge. MACT 11 DK Mangaluru sitting at Puttur DK. Subject to appellant depositing 50% of the award amount within 4 weeks from today before the tribunal. The notice. Agree.
My lord, insurance company challenging liability in quantum.
issue notice pending IA for delay. Stay is taken up. I shall be stay. Order dated 24/10/24 in MVC 2570 of 22. The file of Chief Judge Court of Small Causes, MACT Bengaluru. Take to the appellate. Depositing.
Please tell me. Second list. First list.
50% of the award amount before the,
Second list.
This code, my lord.
for this court within 4 weeks,
There are 4 connected matters, my lord, may be connected.
all along with MFA,
TCS, my lord.
secure trial court records.
Much of it.
You produced
Yes, my lord. In the connected matter before the division bench, it is already stayed. The judgment and award has been produced, my lord.
ಇಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ, connected matter ಅಲ್ಲಿ
Connected matter ಇಲ್ಲಿ ನನ್ನ ಮುಂದೆ ಇದೆಯಾ?
these 4 matters have been
ಅದ್ರಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದೆ
ಎಲ್ಲಿ?
division bench ನಲ್ಲಿ.
ಇಲ್ಲಿ ಬೇಕಾದ್ರೆ
In this, my lord, is 4 matters which are connected.
in one of that certified.
Yes, my lord.
ಕೇಳ್ತಾರೆ. IE 1 of 25 is allowed, certified copy of the judgment is dispensed as the same is produced in.
That I'm not aware, my lord.
ಹೇಳ್ಬೇಕಲ್ಲ. Dispensation application ಹೇಳಿದಿರಾ ಇಲ್ವಾ?
That I'll verify, my lord.
In one of the connected matter. Yes, next.
Much of it.
Insurance companies in appeal challenging the quantum as well as the contributor negligence aspect, Your Lordship.
Notice is already gone?
No,
Caveat is it?
no, Your Lordship, not yet.
You're on caveat, Mr.
I have been
Jagdish.
for caveat respondent.
Yes.
I'll serve the copy of the appeal memo upon them, Your Lordship.
Good.
I have already served upon them, Your
So
Lordship.
notice to respondent number 1. Learned counsel for respondent number 2 on caveat accepts notice, copy to be served on him.
Copy, I have already served,
He
Your Lordship.
acknowledges receipt of the copy of appeal. Pending consideration of IA for delay. IA for stay is taken up. Shall be stay of order dated 13/11/24, MVC 2544 of 23, asked by 21st Additional Small Causes Judge, ACJM Bengaluru, subject to the appellant depositing 50% of the award amount
Before this honorable court. Your
before this court within 4 weeks. On such deposit.
Before
the
that, trial
amount.
court, my lord.
Lordship. When the matter is pending, they'll get
What
to
are you challenging?
contributor negligence as well, Your Lordship, along with the quantum.
Contributory negligence against the
Yes, Your Lordship.
claimant.
Petition. Yes, Your Lordship.
My lord, such a contention is not yet taken that regarding the contribute negligence, only taken that quantum, my lord.
ತಗೊಂಡಿದ್ದೀನಿ ನೋಡಿ, appeal memo ದಲ್ಲಿ ಇದೆ ನೋಡಿ, ground ಇದೆ ನೋಡಿ. I have taken a ground.
Before
Your
this
Lordship.
court within 4 weeks.
A notice to respond one, I have already served a copy upon them, only to, or notice to respond number
R1,
2.
my lord. R2 take notice.
Huh?
R1, my lord, I gave it up.
He is appearing for respond number 1, Your Lord.
R1.
So notice to R2 only.
The other 2 is. You are for R1 ಅಲ್ಲ?
R1, my lord, claimant.
Notice to R2 ಮಾಡಿ.
My lord, 50% amount may be released in.
File a application.
Appeal is by the insurer challenging the liability, quantum, 50%.
Issue notice pending IA for delay. Shall be stay of the order dated judgment and award dated 30th September 24, MVC 809 of 20, passed by Principal Senior Civil Judge CJM Tumkur, subject to the appellant depositing 50% of the award amount
Before the MACT.
before the tribunal upon such a deposit, the amount shall be kept in FD in a nationalized bank. In that case,
How? It can be released because it's only on the quantum years challenge.
the Madam, to release on the amount upon deposit and on appearance of the respondent claimant, the deposited amount shall be released in favor of the respondent bar claimants in accordance to the apportionment made by the tribunal and accordance to the terms and conditions stipulated therein. Amount shall be released by way of electronic transfer to the bank accounts on furnishing of particulars and bank details on proper verification.
Insurance company appeal challenging the liability on the ground that charge sheet was filed against the rider of the motorcycle. Court has held that 50-50 negligence on both the insured vehicle as well as the rider of the motorcycle. Since he was not having a driving license, the rider of the motorcycle was not having a driving license to drive the vehicle, the entire amount is ordered to pay by the insurance company and to recover. Therefore, I am different. I am ready to deposit 50%. It may be.
Third, issue notice pending consideration of IA for delay, stays IA is taken. I shall be stay order dated 4/11/24 in MVC 2968 of 23 passed by 22nd Additional Civil Judge ACJM and MACT Bengaluru, subject to appellant depositing 50% of the award amount before
This court
within 4 weeks from today.
and may be kept in FD for
Still 3 lakhs and orders.
any amount because liability is under challenge.
On such
Instead of
deposit,
laying before melody,
be kept in FD in a nationalized bank.
much.
Maybe not pressed, my lord.
IE 1 of 25 is dismissed as not pressed as appeal is in time.
Claimant's appeal.
Notice.
My lord, appeal by the insurance company challenging negligence, liability and quantum of compensation. I am ready to deposit 50% before High Court. That amount may be kept in a nationalized bank.
Pending consideration of IA for delay, IA for stay is taken up. Shall be stay of operation execution of the order dated 20 September 24 in MVC 11 of 20 on the file of Senior Civil Judge JMFC member MACT Gundlupet, subject to the appellant depositing 50% of the award amount for the
High Court.
this court.
Yes, my
Before
lord.
this court. Within 4 weeks from today.
Much obliged.
Sure notice.
Challenging the liability, my lord. He himself dashed against a stone, and car has been fixed in this case, my lord. Subsequently,
The state of the award dated 7/11/24. In MVC 320 of 19, asked by Senior Civil Judge, Additional MACT, Kollegala, subject to the appellant depositing 50% of the award amount before this court
yes.
within 4 weeks from today. On such deposit, the said amount shall be kept in FD in a nationalized bank until further order.
Much obliged.
Lords, these are petitions against Lords, the discharge orders.
1 minute.
Lords, I'm sorry, Lords, I'm very sorry.
Serial number 1 to 18. Issue notice to respondents. Yes.
Lords, Lords, I'm ready, my Lords, but I only wanted to reiterate for your Lordship's consideration, my Lords. I also inquired with the other counsel in those matters which are posted to the 15th. As I understand, my Lords, all of them involve the same issues. I'm in your Lordship's hands. If your Lordship's direct, my Lords, I'm ready to argue. But I only thought, my Lords, since various parties and various lawyers are involved, would your Lordships consider taking all of them together, my Lords?
Because of this is a mass of it's a revision petition, my lord. Those matters are 482 petition. A revision petition is concerned, scope is concerned, is very limited. And the trial court as well as the earlier round of litigation, co-accused is concerned, my lord, they already dishonorable high court, my lord, there is a prima facie case and dismiss those petitions. It's fully covered by the decision of dishonorable high court. Question of dragging the matter, my lord, this is a 2023 matter. And they are tagged more than 80 matters, my lord. They are saying that, my lord, issue is same, but mines related issue, my lord, this is a different footing. And this case also, my lord, I already filed an objection, and last occasion also I objected to take time.
Issue is the same, my Lords, and I don't know why in a criminal revision, my Lords, your Lordships would also consider whether the trial court has actually sifted through the evidence. In fact, 482 may be a narrower jurisdiction. But, my Lords, ultimately, I'm in your Lordship's hands, my Lords. The petitioner, my Lords, is the exporter. He sold, my Lords, to the exporter a total quantity of 1,89,923 metric tons of iron ore. All these investigations, my Lords, arise out of that Samaj Parivartan Samudaya judgment, where, my Lords, their Lordships in the Honorable Supreme Court directed CBI to investigate into alleged illegal export of ore from the various ports. Now, what happened, my Lords, was CBI, my Lords, directed. In fact, until now, my Lords, the matters have virtually gone hand in hand. This matter and the connected cases. The other cases, I'm sorry, they're not connected, but they all have been posted to the same dates.
How to open this? Which is this criminal petition 5265 of 23?
It's a different issue, my lord.
Those are all, my Lords, in that connected case.
Once they want to take an interim order, my lord, a similar set of issue submitted before this Honorable High Court, as a stay is there. These are the submission in all other matters. And kindly see in my statement of objection, my lord, is I produced two judgment of this Honorable High Court with regard to co-accused is concerned, not any other crime number. It's the same crime number. Co-accused is concerned, my lord. This Honorable High Court is already held that, my lord, there is a case as against the accused. My statement of objection, annexure 4, page number 22. And after that, my lord, they filed a discharge application. Discharge application also considering detailed order passed by the trial court. Again, that order, once again, they approach this Honorable High Court. That is the reason, my lord, there is no, on merits, my lord, they have no case.
Once again is not correct, my Lords. I'm before your Lordships for the first time. 5265, my Lord, your Lordships are posted to 15th of April.
That is a matter filed for quashing.
No. That is also against the same order of discharge.
That is for revision.
That is a 482 petition impugning the same common order in which other accused in these special CCs also filed application for discharge.
This is not 482.
This is not 482.
This is 397.
Those are 482.
Correct.
But they arise out of the same common order of discharge, of rejecting applications for discharge. I, my Lords, was accused 1 and 2 in the CC. I filed this criminal revision petition under 397.
How many cases are there together?
Lords, in that batch, my Lords, I think there are as many as 18 17 or 18.
No, it's a different crime number. They are saying
different-
the bellicary issue, my lord, the Honorable Supreme Court directly investigated the matter below 50,000 metric ton to the SIT Lokayukta. We in a preliminary inquiry conducted, we initiated the proceedings. In the year 2016, my lord, all persons, accused persons approached the Honorable High Court and the matter was stayed. Some of the cases, my lord, we already filed a charge sheet. Some of the cases still under investigation. In the year 2021, my lord, this Honorable High Court, 80 cases, it's a different crime number. This Honorable High Court has dismissed all the petitions. Only one petition, my lord, we have not filed a private complaint. That is the reason, my lord, with liberty, they send it back to the trial court. After the
Petitions which were dismissed were filed for quashing.
quashing petitions,
All right.
more than 30 crime numbers, different accused persons.
It was dismissed on merit or because
On
of-
merits, on merits. I produced the copy of the order in along with the annexure, along with my statement of objection.
Copy of the what charge sheet
It's a copy of the order of this Honorable High Court.
here.
And here, it's a connect, it's a co-accused, not any other crime number. In the same crime number, co-accused filed a criminal petition before this Honorable High Court. This Honorable High Court in detail passed an order, in detail, my lord, considered and what are the ground urged by the, in this petition. It is already considered by this Honorable High Court and dismissed the petition. It's a covered by judgment. What are the grounds urged by?
Oh, now he is here by the discharge application being rejected.
Yes, my lord. But it's a co-accused, similarly placed the accused, co-accused in the same crime number. They approached this Honorable High Court.
Under 482.
482.
There are
That
two
has been
scenarios. No?
Prior to discharge.
He is accused number.
accused number 1 and 2.
Number 1 and 2, my lords, in the
The
special.
accused
cases.
number 1 and 2 are before this court on the discharge application being rejected.
Please,
Yes,
my
ma'am.
lords.
The co-accused who have approached this court under 482 is dismissed.
Correct.
So this court will have to examine whether your discharge application is correctly.
That's so, my lords, which is why, and in the first
Yes.
round, in the 482 petitions for quashing, I was not a party.
Yes, ma'am.
I moved discharge application, it was rejected, I am now before the lordships. Some of those co-accused who moved 482 petitions for quashing in the initial stage, also moved for applications for discharge. They were rejected by the common order, which
What
is
is the
included.
stage of the case now before the trial?
Lords,
court?
it's pending for framing of charge. Your
Charges are
lordships
not
have
framed.
directed the honorable trial court, the honorable sessions judge to defer the framing of charge pending consideration of these petitions. What I was submitting, my lords, was that against this common order rejecting the discharge application.
How many of them filed discharge?
My lords, there were as many as
Mr.
8 or.
Prasad,
Yes,
how many- How many of the accused?
Accused number 1 and 2 filed, in this case, my lord, accused number 1 and 2.
Lords, altogether accused 1 to 10, 13 to 16, 33 to 36, 42, 43 and 45. All moved discharge applications before the Honorable Sessions Court.
A common
That
order.
was rejected by a common order.
Common order.
I moved 397, my lords, I am before your lordships.
What about others?
Some of them, my lords, including your lordships alluded to one writ petition, moved 482. Those are the matters kept for 15th of April.
No, along with you, anybody else whose
Yes.
application for discharge.
Yes, my lords, and is now before your lord. No one is concerned.
Application for discharge rejected
Yes,
has come before this court in revision.
not in revision.
Not
It
in
appears that in 482 they've come.
Have come in 480.
Yes, my lords. And your lordships have kept it for 15th April. Along with other matters,
No
where
other person accused whose application for discharge rejected has come before this court in revision.
lords, there is one revision petition.
In this case, there is
In
no
which,
revision.
my lords, it appears that I'm not sure if it arises from the
So
same.
what will be the material? Nothing much will be different.
No, my lord. See,
Quite so, my
all
lord.
accused is same, simply
No,
placed.
one is considering 482 and 397. The facts would be the same.
Facts, but
The
the
argument also may not be too much of a difference.
in this case, 397 scope is very limited.
Correct. But the argument probably would be almost the same by all others.
That is a say. That is
I
say.
waste the time of the court hearing.
was all-
My difficulty is this, my lord. Each and every time,
He'll fix
one
it.
of the other advocate come and says that, my lord, this is a connected matter is pending.
ಯಾವತ್ತಿರೋದು ಇವಾಗ ಅದು other matters ಯಾವಾಗಿರೋದು?
Different detail.
Illa, illa. All the matters that came on the last date along with my matter have all gone to 15th April. I have placed the copy of the extract from your
Date
lord.
on 15th April.
without any adjournment.
Lord, I am ready. I don't know why my
My
learned friend is
difficulty
putting
is,
me to this group.
next time that advocate will come and they will say some
I
inconvenience.
cannot
can't object
vouchsafe others,
because of that reason, I am opposing. All 80
But
matters
even
were-
today, I am ready to argue. I have no difficulty, my lord. Common issues, I can make a responsible submission arise. I've raised similar issues. I've seen the arguments in the other matters as well.
There is an order of stay granted by this.
It's not to frame it, defer the charges. That is the reason he can't move.
It's only to defer framing of charges.
No, but when you have come before this court in 23.
Yes,
Yes, my lord.
And when the order is passed in 2000,
23 itself.
The order was passed in 23 itself.
January 23.
It's a 2 years, my lord, in each and since from 2016. This is the very same stage. One or the other reason, my lord. That's why if it is a connected matter, then they will come, they will say that it's one of the other advocate taking a time.
1 decade is almost going to be over without moving. a little.
Now they are saying that it's a 2007 incident. That is the reason limitation and question. That's that question is
No, no,
already
I'm
answered
not-
by the Supreme Court as well as the Honorable High Court of Karnataka.
Lord, I'm ready. I'm not avoiding, my lord. I'm ready to go on. I
I
only
am not
wanted
saying
to
that he
place
is
that
avoiding,
submission.
but is it
My
dragging the
learned
issue?
friend, my lord, is, I cannot vouchsafe, my lord, in the other matters what is done, but the issues are the same.
But learned counsel for the petitioner is present. The Aditya Narayan is, your Aditya.
Please,
Narayan, Shri Aditya Narayan is present before the court. He's ready to go on with the matter. He contends that similar matters of challenge to the application for rejection of the discharge filed by the co-accused along with the petitioner are pending before this court in the several petitions which are
Not several petitions, but only one petition they have pointed out, only one petition.
In this
In
matter,
in
one
this matter.
petition, various other issues relating to
That
export
issue
of.
is concerned entirely different, my lord.
My friend
If
must
it is,
let-
another petition is pending before this court on 15th April. Hence, it would be advisable to list this matter also on 15th April. Both the learned counsel shall positively go on with the matter on the said date. Fall on 15th April.
Please, keep your word.
Interim order is
Interim order.
perpetual or continued?
No, my lords, it is continued from day to day.
Order is extended till next date of hearing.
I'm obliged.
I appeal for first respondent.
I appeal for the petitioner, my lord.
Yes.
It is a case of death case, my lord. The petitioner are the father and mother and the brother of the deceased. Well, the trial court has passed an order
Ready.
to pay a sum of rupees 35 lakhs 5,000 rupees to these petitioners. However, the trial court has failed to take the income of the deceased as per exit piece 9, my lord. The trial court has taken as 20,000 rupees plus 40%, as against, my lord, 32,000 rupees plus 40%. Table is in page number 34, my lord. Running page number 34.
What is on page 34?
It is a calculation sheet made by the tribunal, my lord.
34.
Yes, my lord.
Para 24.
24. Yes, para 24, yes.
In para 24, my lord, PW1 deposed that, my lord, at the time of accident, the deceased was aged 24 years and he was working and earning rupees 15,906 rupees per month. And he was also working in a mobile service and earning 12,000 rupees per month. Totaling to, he was earning 27,906 rupees. Whereas the trial court has taken only 20,000 rupees. It is forthcoming in page number, running page number 28. In the middle of the page, my lord. Therefore, the gross salary of the deceased at rupees 20,000 per month is average is taken as income of the deceased. As against 27,906 rupees. My lord. And thereafter, 40% of the present income was future prospect was taken into consideration and accumulated to 28,000 rupees and passed meager amount. That is the
Yes.
The first and foremost, my lord, this is what, my lord, the income of the deceased was taken on the lower side. As against 27,906 rupees, the tribunal has taken 20,000 rupees. And the other rates which has been awarded by the tribunal is not adequate, my lord. It needs to be enhanced by this honorable tribunal, honorable court, my lord.
What are the other heads?
Compensation after, my lord, this is consortium has been awarded for 88,000 rupees, my lord. Loss of estate is only ordered 16,500 rupees and funeral expenses also ordered only 16,500 rupees. Main, my lord, the income needs to be enhanced, my lord. Income of the deceased to be taken into the consideration. Proportionately, the amount will be increased.
All other heads are okay.
All others are, it's inadequate.
Yaudರಲ್ಲಿ?
Well, this is what loss of estate matter only 16,500 has been awarded, my lord.
ಎಷ್ಟು ಕೊಡಬೇಕು?
Needs to be paid 40,000 rupees, my lord. Since there are 3 persons are there. This.
All right. Next. That's all?
Yes, my lord. Main ground is only the income.
Huh?
Main ground is urged in this appeal is only for the taking of the income of the deceased.
But what about other multiplier and deductions and other things?
In accordance with law.
All that is correct.
That is correct, my lord. Multiplier taking into future prospectus. He was 25 years of age at the time of the accident.
Unmarried, is it?
Yes, my is unmarried.
What is the multiplier? 18?
18.
18.
Yes, Mr.
Monthly income is concerned. Is the deceased was not supposed to work simultaneously in two companies, my lord. Despite of that, based on bank statement, the tribunal has considered monthly income at 20,408 on average basis, my lord. That is just and reasonable. So far as the other
which are these two
conventional heads are concerned, just and reasonable.
Which are these two companies?
At the same time, we cannot do both the companies.
They are the reduced one, Mr. Yes, that's all is your argument.
That's all.
Yes, Mr. Counsel.
Yes, my lord, I have produced the document exhibit P9, which clearly establishes my salary slip as a certificate issued by my employers.
P9 records are here.
I don't think so. Records have been not procured.
All right. P9 is
P9 is the salary certificate, my lord.
Which are these companies?
One is Aditya Enterprises, my lord.
What were you working there as?
My lord, I was working as an operator.
An operator. What operator?
Computer operator, my lord.
What was your timing?
Pre-Bo Automotive Private Limited, where I was working as an operator. And in the part-time, my lord, I used to working in the computer service station. I used to earn rupees 12,000 rupees per month as per Exhibit P9.
What is P8?
P8, my lord.
Salary slip. Copy of the letter about salary of the deceased by his employer.
You read page para 24 in Odi. Read para 24 onwards.
Yes, my lord. Para 24. PW1 deposited that at the time of accident, our son was aged about 24 years and he was working as an operator at a Bo Automotive Private Limited and earning rupees 15,906 rupees per month. And he was also working as a mobile service and earning 12,000 rupees per month. And totally he was earning 27,906 rupees per month. And he was contributing his entire earnings towards the maintenance of the family. In support of his evidence, her evidence, she was produced a letter of employer of the deceased about his salary as per Exhibit P8 and P9. And she also produced a bank passbook of the deceased as per Exhibit P13 and P14. Apart from that, she was examined as the marketing manager of Aditya Enterprises as PW2. And he has deposed that deceased was aged about 24 years and he was working on a contract basis at Measures Bo Automotive Private Limited from 9/6/2015 to 20/12/2020 till he met with an accident and he was earning 20,408 rupees per month. In support of his evidence, he has produced the two salary slips of the deceased as per Exhibit P21. In the cross-examination, PW2 suggestions were made that deceased was not employee of Aditya Enterprise and he was not earning 20,408 per month. These suggestions were denied by PW2. PW2 produced an authorization letter issued by his proprietaries of the company as per Exhibit P20. Though PW2 admitted that HR manager of the company will be having information about the employees and their respective salaries, but he has denied that he is not a competent person to depose before the court. Merely because the petitioner has not examined the persons who has issued a letter as per Exhibit P8, the evidence of PW2 cannot be brushed aside when he is authorized to speak on behalf of the proprietaries of Ms. Aditya Enterprises. Moreover, Exhibit P8 is supported by the salary slips of the deceased at Exhibit P21 and also bank passbooks of the deceased Exhibit P13 and P14. In Exhibit P21, the gross salary of the deceased is shown as 20,408 and the net salary is shown as 18,480 rupees per month. Exhibit P21 are the pay slips of the months of October, November 2020. The deceased died on 2/1/2021. The bank passbook of Exhibit P13 and P14. After the permissible deductions, the salary of the deceased was
died on 121.
Yes, my lord. My lord, 2012-2020 actually. 2012-2020.
No, but he died on 2/1/21.
21.
Yes, ma'am. Yes. Accident was taken 2020, died on 2/1/21. Yes, yes, my lord. It is right, my lord. In the past, shall I read, my lord? In bank passbooks, as per Exhibit P13 and P14, after the permissible deduction, the salary of the deceased was credited to his bank account. Hence, considering Exhibit P8, P13, P14, and also P20, it can be safely held that the deceased was working as an operator at a Bo Automotive Private Limited on contract basis from 9/6/2015 to 20/12/2020. Exhibit P8 salary of the deceased mentioned as 15,906 per month, and he was appointed. Therefore, the gross salary mentioned in salary slip Exhibit P21 is to be considered to decide the income of the deceased. Though PW has deposited that her son was working in middle services and earning 12,000 per month, but she has not examined the person who had issued the Exhibit P9. Therefore, merely on Exhibit P9, it cannot be said that apart from his work at Bo Automotive Private Limited, the deceased was working in a mobile service also as a part-time job and he was earning 12,000 per month. Therefore, the total income of the deceased is taken 20,017 rupees per month as per his payslip exhibit P21 subclass 2. This is what, my lord, so far as concerned the income of the declaration made by the tribunal. Now we have to consider whether the gross salary or net salary is to be taken into consideration, the assess of the loss of dependency. The learned counsel for the petition during his argument has relied upon the decision reported in AR 2017 SC 5157. As per the decision, after deducting tax, remaining amount is required to be taken as salary of the deceased. This decision was relied upon by the petitioner counsel in context with the determination of future prospectus of the deceased who was a salaried person. In the payslip of exhibit P21, in deductions column, no amount is deducted towards the professional tax. Therefore, the gross salary of the deceased at rupees 20,000 per month in average is taken as income of the deceased to access the loss of dependency. PW1 has produced SLC mass card of the deceased exhibit P15, wherein the date of birth of the deceased is shown as 28/9/1995. PW also produced the mass card of the deceased exhibit P16, which discloses that deceased studied ITI in government college. By considering the date of birth of the deceased mentioned in exhibit P15 as 28/9/1995, I am of the opinion that the deceased was aged about 25 years as on the date of the accident.
All right.
Yes,
now, what is the material you have produced to show that you are working in the part-time job in the mobile services?
That is what my exhibit P9 is a salary certificate issued by the employer.
Have
The
you examined?
No, that is a tribunal has observed that merely producing the salary certificate issued by the employer does not make out a case of the petition. Therefore, the trial tribunal has not taken into consideration and taken into consideration only the another pay slip of the deceased. And
So,
pass on the
exhibit P8.
Yes, ma'am. P8 has been taken into consideration.
What is the gross salary in P8?
Exhibit P8, my lord. One second.
So, as per your exhibit P21, you are earning 20,017 per month, which is taken.
Yes, my lord. Exhibit P8 is the salary certificate, my lord. It was showing only 15,906. Exhibit P21 is the salary slips.
In that 20,000 is shown.
Yes, ma'am. 20,000 is shown. And
what is wrong?
20,000 is so far as concerned to the first employee. In the part-time, what he is doing, it has not been taken into consideration.
What is the apart from P9? What is the material? What is your timing? How you can work in two different places?
In the evening, he used to go on to the mobile center. He used to do mobile service center. It is a part-time job.
Where is the evidence?
That is there, my lord. He was working from 11/12/2017 to 19/12/2020.
Who was deposed that? Who was said so?
The employee of automobile.
Examined as?
PW2.
The PW2 is another company. So far as concerned to exhibit P9, author has not been examined. The owner has not been examined.
No, this Aditya Enterprises is PW2 was deposed on the behalf of Aditya Enterprises.
Aditya Enterprise is a contractor, and he used to. This petition was working in a contract employee with the Probo. That Probo company was an employer has been examined as PW2.
So Probo, the company in which you are Probo Automotive Private Limited.
That company employer has been examined.
So that is PW2.
PW2.
Yes, ma'am. Yes, ma'am.
All right. And which is the other company you are working?
Mobile services.
Sneha Agencies. I was working as a mobile service center.
In which company? Which is that?
Exit P9.
What is the company?
That is stated as a Sneha and Agencies.
Huh?
Sneha Agencies. Sneha Agencies.
Whom have you examined?
No, except producing the certificate, he has not been examined before the tribunal, my lord.
How that can be considered then?
My lord, since for the petition filing, it is a pleadings is there, my lord, even in the petition as well as in the evidence. And I also produced this certificate issued by that.
Are you IT income tax SSC?
No, man, it's not. It's not coming within the limits
So
of
what
the
is
thing.
this? What is this P13 and 14 bank passbook in other?
Yes, ma'am. Bank passbook, it is wherever the amount has been credited into my account. I have produced this before the tribunal. This is my statement of account. The 20,000 which has been credited to my account has been taken into consideration by the tribunal.
That is from which agency?
Provo, my lord.
Where is the other amount coming to your account?
The other amount was only the cash amount, my lord. I used to pay it.
The cash.
It is mobile center.
What is given 20,000 is correct.
My lord, it is a mobile center. He was 25 years of age and he was doing in the part-time job. That.
Please show me some material.
Exhibit P9 is the material, my lord. Other than that, Exhibit P9, we are not produced any documents. It is there in my petition as well as in my evidence about that I was working in the so-and-so in the part-time job.
That's all?
Yes, my lord, that is the only main thing.
All right, except adding another 40,000.
Yes.
This appeal is preferred by the claimants aggrieved by the inadequate compensation this is not coming. Something is happening here. Awarded by the tribunal. Consequently seeking enhancement of compensation. It is the vehement contention of learned counsel for the appellants that on 20th December 2020 at 7 p.m. while Nagesh TH was riding motorcycle bearing KA-41 EJ-0623 along with his friend T.C. Lohit on T. Ramayana Palya to Tagacha Guppe Road. At that time, when they reached near Alada Mara, the driver of a tractor bearing registration number KA41-T-1396 came in a rash and negligent manner and dashed against the motorcycle of the deceased. Due to the impact, the rider and the pillion rider both fell down, sustained grievous injuries. Though Nagesh was taken and shifted to Sri Rajeshwari Medical College and Hospital, and from there to Nimans Hospital, and thereafter to multi-speciality hospital. Unfortunately, he succumbed to the injuries on 2/1/2021. The claimants who are the dependents of the deceased, namely the parents and brother of the deceased, filed claim petition seeking compensation against the respondent, owner of the offending vehicle and the insurance company. Full stop. New paragraph. Both the respondents filed statement of objections, denied the claim of the claimant, sought for dismissal of the claim petition. Full stop. On the basis of materials placed on record, both oral and documentary, the tribunal awarded total compensation of rupees 35 lakhs 5,000, along with interest at 6% per annum. Fixed the liability jointly against respondent 1 and 2 and directed respondent number 1 insurance company to pay the compensation within 3 months. Full stop. New paragraph. It is a vehement contention of learned counsel for the appellants. The tribunal has awarded inadequate compensation, has not assessed the income in accordance to the pleadings and the materials placed on record. The tribunal has failed to take into account the services rendered by the deceased in another mobile services company, where he was earning rupees 12,000 per month, apart from working as an operator in Pre-Go Automotive Private Limited, where he was drawing income of rupees 20,000 and 17 rupees per month as per exhibit P21 within brackets 2, comma the pay slip. Learned counsel further contends that the tribunal, having failed to take into account the income from other services rendered, has committed an error, and therefore the said income requires to be added along with the income taken by the tribunal, consequently enhance the compensation. It is also contended by learned counsel that under the head of consortium, an additional amount of 40,000 has not been awarded to the sibling of deceased, which requires to be added. On these grounds, he seeks to allow his appeal, consequently enhance the compensation. Full stop. New paragraph. Per contra, learned counsel for the insurance company vehemently contends that the tribunal has awarded just and reasonable compensation. The assessment of the income on the basis of exhibit P21 within bracket 2 is correct. The finding of the tribunal is justified. He contends that the appellants have not produced any material cogent to show that the deceased was working in the second company in the mobile services and earning rupees 12,000. No material is placed and so also no one is examined to support such contention. Hence, the person cannot work in two different places, and if at all he has worked, unless material is placed before the court to the satisfaction of the court, same cannot be allowed, which is rightly done by the tribunal. He also contends on all other heads, reasonable compensation is awarded which does not call for interference. Consequently, he seeks a rejection of the appeal. Full stop. New paragraph. I have heard learned counsel for the appellants and learned counsel for the respondent insurance company. The occurrence of accident, involvement of the vehicles, deceased having met with the road traffic accident and consequently succumbing to the said injuries on 2/1/2021 are all established and proved by production of exhibit P1 to P21. Claimant have examined PW2 to substantiate exhibit P21 to show the income of 20,017 rupees per month. The same is accepted by the tribunal. Income is taken as 20,000 per month. Age of the deceased as on date of occurrence of accident was 25 years. The appropriate multiplier is taken at 18, which is correct, does not call for interference. In view of deceased being aged less than 40 years, future prospects at 40% is added. And towards personal deduction of personal expenses and living expenses, 50% is deducted, which also does not call for interference. Therefore, I do not find any good ground, cogent reason to interfere with the loss of dependency awarded by the tribunal at 30,24,000. Same is retained. Towards loss of estate, funeral expenses, 16,500 awarded is retained. So also towards loss of filial consortium for petitioners 1 and 2, petitioners per claimants 1 and 2 at 88,000 is retained. However, I am in agreement with learned counsel for the appellants that since the third appellant is the sibling, is also entitled to loss of consortium at rupees 40,000, and adding the escalation of 10%, 44,000 is required to be added to the head of consortium, in addition to the amount awarded at 88,000 by the tribunal. Full stop. Medical expenses of 3,60,000 is retained. Full stop. In view of the above discussions, I pass the following order. The appellants are entitled to total compensation of rupees 35,49,000 as against 35,05,000 awarded by the tribunal. Full stop. Accordingly, I pass the following order. The appeal is allowed in part. The judgment and award passed by the tribunal is modified. Appellants are entitled to total compensation of 35,49,000 as against 35,05,000, along with interest at 6% per annum. The balance compensation shall be paid by the respondent insurance company within a period of 4 weeks from the date of receipt of copy of the order. All other terms and conditions stipulated by the tribunal stands intact and is retained. So also with regard to disbursement, release, apportionment, as per the order of the tribunal, ordered accordingly.
to show that she was removed from the job. On considering the evidence available record, the petitioner might have affected the vocation to disability of 50%. That in this case, and she herself has given the evidence before the court. Right? She has herself has given the evidence before the court. Further, the doctor is not a treated doctor, and she has not produced any rehabilitation course or something to accurate the cognitive disability. Considering that, my lord, and they say that means she was working in a garment. She has not placed any document to show that she has removed. Considering all these aspects, my lord, though the court has taken 50%, can't meet it is just unreasonable. Only thing is, my lord, involve that apex court judgment. Pay and recovery order has to be passed.
Pay and recovery because of no license. Huh?
No license.
That anyway is going to be passed. Now you have to argue on this salary and income.
They are not entitled to get
even salary and income. That also is negative because of no document. That
they are asking for the disability considering the PW2 evidence.
Yes.
That's my lord. The PW2 is not the doctor, treated doctor. She has given the evidence. No rehabilitation course was conducted to the petitioner, and the petitioner herself has given the evidence before the court. If this type of injury, the disability is definitely she is not in a position to give the evidence before the court.
There is evidence.
The doctor says that when a cognitive disability, when the severe cognitive disability, if it is, she is not in a position to give the evidence before the court.
You the top exhibits. Which are the exhibits? Why don't you people in the insurance company do your own clinical examination of the patient?
Once she has given the evidence before the court, itself indicates that she is capable to answer.
All right. Did you controvert the evidence of the doctor PW2 with regard to 89% disability?
That's what meant she is not a treated doctor. That was elicited.
All right. Let us see your evidence.
In the cross-examination, it was called out in the judgment itself.
Let us see your evidence.
Please.
What is the cross-examination? Tell me what is there in the evidence in your favor. What is there in the evidence?
The PW2 in the cross-examination at length, the counsel for the response. The judgment in page 30 of the judgment, a disability at next page.
30. PW2 cross-examined at length.
Learning counsel for the respondent insurance company. No doubt that PW2 is not a practicing doctor, but she is working as a professor in the Department of Clinical Psychology. No doubt the petitioner has examined herself before the court and answered the question put to her at the time of cross-examination. The answers given by the PW1 petitioner at the time of cross-examination regarding the fact of the accident negligence is proper. Nothing has been elicited so. While petitioner can answer the fact of accident a proper accurate way, whether evidence of PW2 regarding the cognitive can be considered or not has to be looked into. No doubt the petitioner normal life is undisturbed by, but as per the evidence, doctor, complex situation petition cannot behave normally. As admitted the PW2 cross-examination, IQ level of the petitioner is not mentioned in her affidavit, but she has mentioned the social quotient level of 36%. The GCS score of the petitioner is 14. As per PW2, the petitioners behave normal in simple comprehensive situation, but in the complex situation, the condition of petitioner impairment considering the same. For a person leading his life in a normal way without depending on other, to have a behave and react normally in both normal and complex situation. The cognitive disability petitioner is assessed it, even though it is stated that petitioner was working so and so. That was ridiculous. If that disability, she is not in a position, according to the medically, she is not fit to give an evidence. But even abnormality is concerned, court has not observed anything regarding while giving the evidence. when such being the case, my lord, the disability which is assessed by the doctor who is not the treated the petitioner, it is on the side. Considering that, my lord, the court has taken 50% of disability.
No. What is the basis of the court taking 50%? Please tell me that.
But that
is
is
an
my lord, the
expert. Court is an expert in medicals. Has
No,
done
hence-
MBBS, has done psychology and psychiatry. Cognitive disability course ಮಾಡಿದಾರಾ?
ಇಲ್ಲ. The court or matter basing on the evidence and the cross examination. My lord, we have elicited based on the medical literature where the how the disability assessed or to by the doctor.
There is a observation in the judgment. Petitioner unable to walk independently was brought by her son.
Who has stated that?
In the judgment, doctor has stated.
He is saying the doctor's statement is cannot be believed is his version. Now you have to tell what the judge has said after seeing the patient walking in from the door.
No, my lord. No observation.
Yes, read your cross-examination.
Sorry, my lord, the cross examination portion is not available.
So this PW2 is, what is her qualification?
Neuropsychologist.
Huh?
Neuropsychologist.
Qualification, she is a diploma holder in a this thing, my lord. She is working in a rehabilitation center in the NIMANS.
Working as professor neuropsychology, Department of Clinical Psychology.
That is the rehabilitation center which is run by the NIMANS hospital where she is working.
So she was taken to the new rehabilitation center.
But rehabilitation was not given. Straight away she has assessed the disability.
As rehabilitation center ಇಡ್ತಾರೆ ಅವ್ರನ್ನ.
No, but as normally in a course of rehabilitation, they have to give a 5 to 7 session for conducting on understanding of the IQ level of that patient. They have to give some questions and all. Maintaining those, my lord, they have to assess the report. But here is the case, my lord, no such rehabilitation course was conducted. Straight away they have given the assessment.
In this case, Exhibit P13.
No document were placed before this court how the rehabilitation was given. Only neuropsychological assessment was given.
Assessment report is there.
All tests conducted, she is showing impaired. Have you seen the photographs and other things?
I have seen that.
So all the tests that is conducted in
If
2023.
My respectful submission before your lordship is, if that situation, whether she is capable to give evidence or not is the question.
Why she
My lord,
cannot give?
it is very difficult, my lord, when such difficult, the deficit and the neurological cognitive disability, she is not in a position to give evidence, but
There
in
are
this
several
case, she has given.
types of neurological cognitive disabilities.
Please.
Once there is a head injury, there is no doubt, there is no dispute. Head injury and there is several types of cognitive disabilities.
Please.
It ranges from person to person on the gravity and magnitude of the injury. He may be able to ask and he may be able to answer the name and other things, but may not be able to identify colors and complex questions.
Correct.
So here, that is what the doctor has said, that she is unable to do complex things.
Correct, man. That's what, my lord, she is incapable to understand the simple thing. She may not understood the complex problem. For that, my lord, court has taken 50% disability. Here is, my lord, if she is not capable to give evidence, as somebody was given the evidence, the disability what the doctors say, see, it can be taken. But here is the case, my lord, she has not the treated doctor, and she has not treated at any point of time to the patient. Only based on the document, she has deposed before the court. On the contrary, if she is not able to, the doctor says that there is a slur in speech according to her evidence. But when she has given the evidence before the court, there is no such observation from the court says there is a slur in speech. Considering these aspects, observation of when there is no observation by the court.
Simple thing is how the court can sit over a judgment of a medical expert. That please you answer that. If I agree with everything, whether this has been dealt with by some judicial magistrate or even a sessions judge. Is a sessions judge capable of analyzing a cognitive disability of a patient, which is analyzed by a medical student after doing MBBS and then post-graduation and maybe a super specialty? What is the qualification I have to decide on a patient? Suppose you come and stand. How I can assess the cognitive disability?
It is correct, man. The expert only assess the disability.
What have you done to contra that?
I have elicited, she is not capable to, because she is not a treated doctor and she is not a practicing doctor, she is only a professor and she has never treated the patient. If at all, that is the, she may be referred to a medical board. Let the report may be given by the medical board that we can
Why I
consider.
Should do that? Why I should do that? You are not in appeal. You have not come before the court.
That's what, when she has given the evidence.
If you have come before the court, then the question of referring would arise.
There is no liability on that day to challenge this order. That is the problem we are facing. Since the liability was fastened on the owner of the vehicle, I have no option to challenge that order.
You have been exonerated.
Please.
All right. Now, after he filed here, you could have filed cross objection.
Liability in a how I can challenge that?
All right.
When there is no order against
so only pay and recovery is what. So now the respondent number 2 is not here. 1 or 2?
Owner.
Two.
Not served?
Served.
Yes, served with notice.
Unrepresented.
See, all these kind of matters, you should be more careful and meticulous in your examination before the trial court tribunal.
Correct, but at the same time, can we take the assessment of the doctor who has not qualified?
I will tell you one simple thing. Now, we are seeing many persons in our courts who are walking around advocates.
Please.
You don't know what is going on with each one of the person. He may be appearing.
It is different.
I will tell you one small example. I was sitting in one temple, watching one person, walking, going, coming, sitting, doing all prayers, puja, everything, like a normal man. One fine day, I got introduced to that person's parents. And the person's parents incidentally told me that he is having some mental issue.
It is true.
Which I could not realize or could not even know. Later on came to know that he is suffering from IQ deficiency. And he is in such a position that if he sits right under the fan and sweating, he would not know that if he goes and switches on the fan that this will get sorted out.
Man.
But he will not know how to do any work. If you ask him to sit and open one box and close it, teach him, he will do it. He will know to take one bus from A point to B point and come back from B point to A point. That's all. If he gets in between lost, he will not know where to do, what to do. Cognitive disability, another.
It is.
He has come before the court, she has answered. You see the injury that she has suffered and the treatment she has undergone. 38-year-old lady.
It is true, my lord. According to my little knowledge, I am not an expert. A little knowledge, what I have understood, my lord, with this type of cognitive disability, if she is having, definitely she is not in a position to give an evidence. But
That
for
is
that,
not,
my lord,
no,
for
that is not stated by your the honorable the learned judge anywhere.
No, it is discussed. We have put the question to the doctor. She is not a treated doctor. She has given the evidence.
Where have you put this question to the victim?
This in the
claimant?
cross-examination. We have
Claimant. Where have you put this question to the claimant? Let us see your cross-examination to the claimant.
regarding disability is concerned, my lord, at that point of time.
No, let us
it
see
will
what is
not-
your cross-examination to the claimant. Read that.
Yes, sir.
And is it not the duty of the tribunal to note that?
No,
When there is a
normally court will observe if some abnormality is what they have observed. But it is not a mandatory, but normally what I have seen, my lord, it will be observed. ಪಾರ್ಟಿ ಸವಾಲು ಒಂದು ಅಪಘಾತ ಮಂಗಲದ್ದು ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರದ ವಿಷಯಗಳು ಮತ್ತು ನಾನು ಹಾಜರುಪಡಿಸುವ ದಾಖಲೆಗಳು ಗೊತ್ತಿದೆ. ಅಪಘಾತದ ಸಂದರ್ಭದಲ್ಲಿ ಮಂಗಳವಾಡಿಯಿಂದ ನನ್ನ ಮಗಳ ಮನೆಗೆ ನಡೆದುಕೊಂಡು ನಾನೊಬ್ಬಳೇ ಹೋಗುತ್ತಿದ್ದೆ. ರಸ್ತೆಯ ಎಡಬದಿಯಲ್ಲಿ ಇತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ರಸ್ತೆಯಲ್ಲೇ ನಡೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದ ನನ್ನ ತಪ್ಪಿನಿಂದ ಅಪಘಾತವಾಗಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ರವಿಕುಮಾರ್ ನನ್ನ ಅಳಿಯ ಈ ಅಪಘಾತವನ್ನು ನೋಡಿಲ್ಲ. ಅವರು ಅಪಘಾತವನ್ನು ನೋಡಿಲ್ಲ. ಅಪಘಾತದ ಸಂಬಂಧ ಪೊಲೀಸರು ನನ್ನಿಂದ ಹೇಳಿಕೆ ಪಡೆದಿದ್ದಾರೆ. ಅಪಘಾತದ ಕೂಡಲೇ ಹಾರೋಹಳ್ಳಿಯಲ್ಲಿ ದಯಾನಂದ ಸಾಗರ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿ ಪ್ರಥಮ ಚಿಕಿತ್ಸೆ ಪಡೆದು ನಂತರ ನಿಮಾನ್ಸ್ಗೆ ಹೋಗಿ 3 ದಿನ ಒಳರೋಗಿಯಾಗಿ ಚಿಕಿತ್ಸೆ ಪಡೆದು ಪುನಃ 2 ಬಾರಿ ದಾಖಲಾಗಿದ್ದೇನೆ. ಈಗ ನನ್ನ ಫೋಟೋವನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಬಹುದು. ನಿಶಾನೆ 5 ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಪ್ರಕಾರ ನಾನು 18,000 ರೂಗಳನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ. ಉಳಿದ ಮೊತ್ತವನ್ನು SKS ನಿಂದ ಧನ ಸಹಾಯ ಮಾಡಲಾಗಿದೆ ಎಂದರೆ ಸರಿ. ನಿಮಾನ್ಸ್ ಆಸ್ಪತ್ರೆ ನನಗೆ ಉಚಿತ ಚಿಕಿತ್ಸೆ ನೀಡಿದರೂ ಸಹ ಮೆಡಿಕಲ್ ಬಿಲ್ ಸೃಷ್ಟಿ ಮಾಡಿ ಹಾಜರುಪಡಿಸಿದೆ ಎಂದ್ರು ಸುಳ್ಳು. ವೈದ್ಯಕೀಯ ಮತ್ತು ಇತರೆ ವೆಚ್ಚಗಳಾಗಿ 1.25 ಲಕ್ಷ ಖರ್ಚು ಮಾಡಿದರೆ ಸರಿಯಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಪ್ರಕಾರ ನನ್ನನ್ನು ಗೃಹಿಣಿ ಎಂದು ತೋರಿಸಿದ್ದರೂ ಸಹ ಗಾರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದಾನೆ ಅಂತ ಸರಿಯಲ್ಲ. ನಿಮಾನ್ಸ್ ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಪಡೆದಿಲ್ಲ. ಅಪಘಾತದ ನಂತರ ನಾನು ಕನ್ನಡಕ ಉಪಯೋಗಿಸುತ್ತಿದ್ದೇನೆ. ಅಪಘಾತಕ್ಕಿಂತ ಮೊದಲಿಂದಲೂ ಕನ್ನಡಕ ಉಪಯೋಗಿಸುತ್ತಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಕೇಳಿದ ಪ್ರಶ್ನೆಗಳೆಲ್ಲ ಅರ್ಥವಾಗುತ್ತಿದೆಯೇ ಎಂಬ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿಯು ಅರ್ಥವಾಗುತ್ತಿದೆ ಎಂದು ಹೇಳಿರುತ್ತಾರೆ. ನನಗೆ ಜ್ಞಾಪಕ ಶಕ್ತಿ ಕುಂಠಿತವೆಂದು ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಹಾಯಕಿಯಾಗಿ ಕೆಲಸ ಮಾಡಿ 18,000 ರು ಸಂಪಾದನೆ ಮಾಡುತ್ತಿದೆ ಎಂದು ಹೇಳಿದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ ಯಾವುದೇ ರೀತಿಯ ತೊಂದರೆ ಇಲ್ಲದೆ ಹೊರತುಯೂ ಮೊದಲಿನಂತೆ ಸದೃಢವಾಗಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ತಪ್ಪಿನಿಂದ ಅಪಘಾತವಾಗಿರುವುದರಿಂದ ಎದುರುದಾರರು ಬಾಧ್ಯಸ್ಥರಲ್ಲ ಎಂದರೆ ಸರಿ.
So now the tribunal has granted future prospects also.
It is granted.
Considered.
And conventional areas. The accident happened on 25/11/2020. The last surgery was conducted on 1/7/2021 after 8 months.
No, it is not the question of when the surgery was conducted and after how many period. It is a question of what is the status, the mental status and the disability. That is the issue. You may have incurred several injuries, several surgeries over a period of time, 1 year to 5 years. But what is the present status?
Present status, she cannot walk independently without support.
But she has walked to inside the,
with
come
support,
to the court,
with-
she has given evidence.
With support,
With
his
support.
son. Yes.
She has got into the witness box, withstood the cross-examination of the counsel.
Yes, with the difficulty she has given.
And where have you said in your evidence that she is unable to identify the colors, unable to identify this, identify that, do this work, do that work? Where have you stated?
This, in the evidence, I am not able to do any work.
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ನೀವು?
In the affidavit.
Where is that statement made by you that you can't do any work by yourself independently and you need one attendant? Where is it?
In page 2, madam. Deposition of the petitioner 1, page 2, para 3. After the accident, I'm getting a headache and conditions often and often. I have lost my memory power and also have lost my right eyesight, not able to walk and stand in sunlight, not able to carry any weight on my head. Prior to this accident, I was working as a helper at Laguna Garments Clothing LLB at Kanakpura town, and I was getting a salary of rupees 18,000 per month. After this accident, due to injuries and permanent disability, I left the job as I am not able to do any work.
Yes.
This.
Nothing prevented you from suggesting for a medical additional checkup from any other authority if you are not satisfied with. This is not a private hospital, it is NIMHANS.
No, that she has not the prior to the going to the Niman's hospital, she went to Dayanand Sagar hospital where first aid treatment. In the Niman's hospital, she has admitted for 3 days.
First time 3 days. 3 times he was.
3 days. Thereafter, she has admitted on 6 days in the same hospital. The question is, my lord, when the claim petition was dismissed,
initially,
no.
In the award, after contesting the matter, my lord, by appreciating the evidence on record, court has dismissed the claim petition against the insurance company. I have no opportunity to challenge that order.
No, I'm not talking about you, about your insured. He has not participated?
He has not participated, my lord. Therefore, the liability was passed on him.
No.
Since
now, before the tribunal, you contested.
I have contested.
At that time, you are not aware at the time of trial that you are going to be exonerated.
No. We are aware. In addition to that, my lord, she said that she was working in a garment.
Forget about whether she was working or not working. That is immaterial. Whether she joined back, she got the job, she discontinued, that is immaterial for deciding her cognitive disability. The fact remains that the doctor has given a treatment. Treatment given, undertaken by her is not disputed by you. You cannot dispute.
No, she has not given treatment at all.
Not this lady, sir. This lady may not be the person who was treated.
Correct.
But she has undergone surgery. They have cut open her head and done the stitches on the head and the stomach. All that is a material document available on record. You have not disputed that.
We have not disputed.
You cannot dispute it also. It's a matter of record.
The nature of injury, what she has sustained.
The only thing
now,
what
cognitive disability assessed by the doctor is on the higher side, and she is not disabled. What according to the doctor?
Right. Where is that
evidence?
By you? Where is that by you? If that was the case, till the decision of the tribunal, you are not aware that you are going to be exonerated, and only everything is going to be fastened on the owner.
There is another thought, my lord. She is working according to her evidence. She was working in a Laguna garment. If that disability, she would have produced the termination letter that was not placed before the court. Therefore, we are under the impression that the disability will not be taken into consideration.
The doctor who has given the assessment is working
In the man's assessment.
ಹೌದಲ್ಲ?
Rehabilitation.
ಮತ್ತೆ how to disbelieve her? Working as an assistant professor
in
of neuropsychology department of
Psychology
clinical
department.
psychology in NIMHANS.
She is only a professor. She is not treated the patient. No document were placed before the court. How she has conducted the rehabilitation course?
All materials are here.
No, that is not that is the assessment sheet she has produced, not the report.
No, there are materials
Neuro
here.
behavioral report has to be conducted to the patient considering her nature, IQ level, the
Sir, all that is
understanding
placed
level
here.
of
You
the
have not
patient,
probably read it.
and the family background of that patient has to be adjudicated in the
Exhibit P13
course.
neuropsychology assessment.
That assessment report is there, psychology.
P13.
13.
30?
P13.
Exhibit P13.
13. Neuropsychological assessment report.
As per the medical literature of the man's, what I have understood, my lord, before assessing the neuropsychological report, the patient has to undergo rehabilitation course, half-annually.
Not required.
Such a report is not placed before the court to know the status mind of that patient.
Rehabilitation is different. Cognitive disability is different. Rehabilitation is
What the understanding of mind, Mela,
No,
basing on the rehabilitation's report, the cognitive and behavioral report has to be given by the neurologist, psychologist.
neuropsychological unit, Department of Clinical Psychology, neuropsychological assessment report.
That is
ಕೊಟ್ಟಿದ್ದಾರಲ್ರಿ ಇಲ್ಲಿ ಇದೆಯಲ್ಲ ಇದು
psychologist report which
Professor
was
and in
prepared.
charge. Huh?
But before assessing or preparing this report, they see the doctor has to assess the status mind of the person, the patient. That is called rehabilitation course. That has to be conducted up to 5 or 6. Basing on that report, the answer they have to give the report. In this case, no such rehabilitation course was conducted before issuing this certificate. Therefore,
ಕಡಿಮೆ ಆಯ್ತು ಅವ್ರು.
I have seen
this.
Why
this court should not believe that? Just tell me that.
This is my argument, Maladda.
No, I understand, but I have to understand your argument too.
But this is before giving this report, Malad, the patient has to undergo a rehabilitation course where they will give us several questions for that, considering the status mind of the patient, considering the family background of that patient, understanding the IQ. All these tests has to be conducted. Basing on that, Malad, this report has to be issued as per my knowledge and the literature.
Your knowledge is please show me some medical lecture or some teachings on that. That what you are saying has to be done to assess a cognitive disability. That has to be done on the medical literature. So, ನಿಮ್ಮ medical literature ಪ್ರಕಾರ ನಾವು ಹೋಗ್ಬೇಕು.
It is not my understanding.
Show me that.
It is not.
We can't go on your and my understanding or the learned tribunal's understanding. We have to go on the expert's understanding. If that is the case, then show me that literature. I'll agree with you.
2 weeks time, maybe grant minute, I will try my level best to assist the court.
Because as per my understanding, once there is a disability of head injury, the neurosurgeon and neuropsychologist and neurophysician. These are the three persons who are concerned with your head.
Correct.
Then there is a spine which is different, a spine surgeon is different.
Please.
So head, a neurosurgeon, neurophysician, neuropsychologist, and if there is psychiatric problem, there's a psychiatrist.
Please.
Will come into play. If they have given all these assessment and treatment and the decision and diagnosis, already this lady being assistant professor based on the report and diagnosis can make out this.
She's an assistant professor in a psychology. Correct, Malat? If that psychology deficit was made available, it has to be observed in the court where she has given the evidence standing on the long hours. She has answered for the several questions.
Don't go
not
by
one
that.
or two questions.
Don't go by a person standing before the court. Don't go by that. A person may stand, again, as she has stated, doctor has stated, she cannot stand in the sun. She will start having headache. She may fall down. She may be finding difficulty in looking down and walking down the stairs. She may start having seizures. She may start having epilepsy. All these are the situation that happens in head injury. Learned counsel for the respondent insurance company seeks a week's accommodation.
Not 2 weeks time.
2 weeks accommodation. You show this to any of your expert and give a private opinion from your insurance company. If that is going to be different from what is assessed here, we'll see whether it has to be further referred to anybody else with the patient.
Please, I'll search regarding that cognitive, how the cognitive disability has to be assessed. I had some books. I will look into them.
Instead of that, why don't we refer to any other person for a assessment?
When medical board is there, my lord, if it is assessed,
instead of doing
we will
all this
agree
within a
for
week's
that
time,
also.
that report will come.
Date maybe.
Medical board,
Pass an order now, verbally.
please.
The learned counsel for the appellant and learned counsel for the respondent are present. The Vimala is the patient. Who's the doctor? What's her name?
Jamuna Devi.
Jamana. Rajshekar.
That the document Kodima report. Jamuna Devi. Who assigned that?
Usually ಅವರೇ ಮಾಡ್ತಾರೆ ಸಮಯದಲ್ಲಿ.
So Jamuna is Shidhara.
Jamuna Rajeshwari.
Rajeshwaran.
Rajeshwaran, professor in charge, neuropsychology unit, Department of Clinical Psychology.
Nimans.
Learned counsel for the appellant contends that the assessment made by PW2, who's a neuropsychologist,
Please.
assistant professor of
Clinical psychology.
assistant professor
In
Working as
clinical psychology.
working as a
neuropsychology
professor of
unit, Department of Clinical Psychology, enhance, has adduced evidence opined disability of 89.65% cognitive disability as per RPWD Act 2017, and has also stated that disability is permanent in nature. The patient is not able to do any manual work, whereas the tribunal, while assessing the disability, is assessed the disability to be 50%. The learned counsel for the respondent insurance company sustains the finding of the tribunal of assessing cognitive disability at 50%. Whereas the opinion expressed by PW2, who's an expert in the field of medicine, runs contrary to the opinion expressed by the tribunal. Under the circumstances, this court deems it appropriate to refer this matter to the medical board for assessment of cognitive disability. On examining the patient, the appellant herein. Under the circumstances, the appellant is directed to appear before the medical board. Yaudadu? Victoria, which is that? That was we have on. Neuropsychology unit, Department of same clinical psychology in enhance. Iವ್ರಿಗೆ ಹೋಗುತ್ತೆ. Neuropsychological assessment for neuropsychological assessment report. After examining the appellant, namely Srimati Vimala HM, wife of late Bandi Gowda. Full stop. The appellant will keep herself present before the medical board.
Please.
Yes, Mr. Girimalaya. Medical board on. Yavag hogtira?
After 1 week in a day.
On 9th April. On 9th April at 11 a.m. This court, the medical board is requested to furnish a report by 16th April. All right?
ಅಷ್ಟೊಂದು ಹತ್ರ ಆಗುತ್ತೆ ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಡೇಟ್ ಇಲ್ಲ ಡಾಕ್ಟರ್ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಇಫ್ ದಿ ಪ್ರೊಸೀಜರ್ ಇಸ್ ಫಾಲೋಡ್ ಮೇಲೆ ಒಂದ್ 4-5 ಸರಿ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಐ ಡೋಂಟ್ ನೋ ಆಸ್ ಪರ್ ಮೈ ಲಿಟಲ್ ನಾಲೆಡ್ಜ್ ಅದರಿಂದ ಅಷ್ಟೇ. ಹಂಗಾಗಿ ನಾನು ಡೇಟ್ ಜಾಸ್ತಿ ಕೊಡಿ.
It is not so complex as you think. This is very easily they can make out.
Please, then
simple reading of it. Simple reading, patient walking from there and 2 questions, they will know what it is.
Correct.
That is the expertise they develop. These neuropsychologists, neurosurgeons. It is not so complex as what you think. But of course, their patient will have complex issues. Patient will have even color identification of the color, sound, hearing something which is not happening. Namgu nimu gottagalla. It's so complex.
ನಂಗೂ ಒಂದ್ಸರಿ ಈ ತರದ್ದು ಆಯ್ತು ಸ್ವಾಮಿ. ನಾನು ಪೇಷಂಟ್ ಒಂದೇ ವಾಶ್ರೂಮ್ಗೆ ಹೋಗಿದ್ವಿ. ಬಟ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಇದೇ ಪೇಷಂಟ್ ಅಂತ. ಅದೇ ಪೇಷಂಟ್ ಕೋರ್ಟ್ಗಳೇ ಬಂದು ಇದ್ರ ಒಳಗಡೆ ಕುತ್ಕೊಂಡು ಅಲ್ಲಿ ಯೂರಿನೇಟ್ ಮಾಡಿದ್ರು ಕೋರ್ಟಲ್ಲೇ ಮಾಡಿದ್ರು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಲ್ಲಿ ಬಂದ್ರು, ಇಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ, ಅಲ್ಲೇ ಅದೇ ವ್ಯಕ್ತಿ ಅಲ್ಲಿ ಬಂದ್ ಮಾಡಿದ್ರು.
Because the control over the bladder also loses. So
I have come across.
Not only this, when there is a head injury, spine injury and all that, once they open up, everything, all your organs get affected. So you will lose control of your bladder movements. That is why bowel movements also will lose control. It is not within your hands.
It depends.
The comprehension also will not be there. When you have to do, when you have to go, all that you will lose.
It is correct.
That is a problem. Many, this will generally happen to also people who are not suffering from head injury, aged parents, aged persons.
Age factor.
It is. All right. Call after a week, 2 weeks after 9th.
Date.
2 weeks after that, let it come. Call on 24th.
That's what.
All other matters in the afternoon.
Much.
Lordship, a submission. List 3, serial number 27. I'm filing memo of withdrawal.
Good. List 3, serial number
27.
27.
I'm for the petitioner, my lord.
Vidya.
Yes, my lord.
Yes, Learned Counsel for the petitioner files a memo seeking withdrawal. The memo and submission placed on record, petition is dismissed as withdrawn.
Please, my lord.
My lords, list 3, serial number 19, my lords. I'm filing memo for dismissal, my lords. Petition has become infructuous, my lords.
19.
Huh?
My lord, serial number 39, my lord. Serial number 39. Serial number 39.
What do you want? 39, 39.
Sorry, sorry, my lord. Stay, my lord. Sorry, stay.
Now the stay.
Appeal by the Reliance General Insurance Company.
ಸ್ಟೇ ಆಯ್ತಾ? ಸ್ಟೇ ಆಗಿದೆ ಅಲ್ವಾ? ಸರಿ, ಸ್ಟೇ ಕೊಡ್ಬೇಕು ನಿಮ್ಗೆ.
ಅಲ್ಲ 39. Sorry, 48, my lord. Sorry, 48.
ಅದು ರೀಚ್ ಆದಾಗ ನೋಡೋಣ.
ಪ್ಲೀಸ್.
ಅವಾಗ ನಮ್ಮ ಮೈಂಡ್ ಏನಾಗುತ್ತೆ ಗೊತ್ತಿಲ್ಲಲ್ಲ.
ಪ್ಲೀಸ್.
ಸ್ಟೇ ಕೊಡ್ಬೇಕಾ ಇಲ್ಲ ಅಂತ ಅವಾಗ
ಏನು ಆಗಲ್ಲ. Your lordship is not like that.
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಆ ಕೇಸಲ್ಲಿ? That criminal revision, criminal petition. Review petition. Revision petition.
Yes.
Have you found out?
Yes, my lord. They issued one letter, director of prosecution. So they are ascertaining, but they issued one letter. I will submit.
Sir, simple small thing, whether the trial is conducted by the same PP in both the case or not.
Different PPs are conducted in the case.
ನೀವು ಸುಮ್ಮನೆ ಹಂಗೆ ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ. His main argument is that in a case and counter case, there has to be two different PPs, but same court. Two different PPs ಮಾಡಿದ್ರೆ, then your case is. Otherwise, it has to go simple.
I will submit.
You can't. One case you are arguing for complainant. In the other case, you are arguing for accused. You get this rectified.
exorbitant here, sir. 15,250 rupees. Whereas
Court officer? Court officer? Court officer?
ಸರ್ ಹೇಳಿ
ಏನ್ ಸಿಟಿಂಗ್ ಲೇಟಾ? ಸಿಟಿಂಗ್ ಲೇಟಾ?
ಇಲ್ಲ ಸರ್ ಬಂದಿಲ್ಲ ಇನ್ನು ಬರ್ತಾರೆ ಸರ್.
ಹೌದಾ? ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ಲ ಲೇಟ್ ಅಂತ ಬರ್ತಾರೆ.
ಥ್ಯಾಂಕ್ಸ್ ಮೇಡಮ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಅದೇ ಲಿಸ್ಟ್ ನಂಬರ್ ಇವಾಗ ಲಂಚ್ ಟೈಮ್ ಹತ್ರ ತಮ್ಮ ಹತ್ರ ಮಾತಾಡಿದ್ದೆ ನಾನು. ಲಿಸ್ಟ್ 3 ನಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ಸ್ ಇತ್ತು, ಇಟ್ ಕೆನಾಟ್ ಗೋ ಫಾರ್ ಲೋಕ್ ಅದಾಲತ್. ಸೊ ದೇರ್ ಫಾರ್ ಐ ವಿಲ್ ಮೇಕ್ ಎ ಮೆನ್ಷನ್.
ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿ ಸರ್, ಮೆನ್ಷನ್ ಮಾಡಿ.
ಥ್ಯಾಂಕ್ ಯು.
ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವುದು?
48.
ಓಕೆ ಸರ್, ಮೆನ್ಷನ್ ಮಾಡಿ.
ಓಕೆ ಮ್ಯಾಮ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 52.
ಯಾವ ಲಿಸ್ಟ್ ಸರ್?
ಲಿಸ್ಟ್ 1.
ಇದೆ ಇದೆ.
ಆನ್ಲೈನ್ ಅಪೇರ್ ಆಗ್ತಿರ್ತೀನಿ ಅದಕ್ಕೆ.
ಬನ್ನಿ ಸರ್, ಬನ್ನಿ, ಆನ್ಲೈನ್ ಅಲ್ಲೇ ಬನ್ನಿ.
with my lord's kind permission, my lord.
Yes.
List number 3, serial number 48, my lord. I was informed that all the matters are referred for Lok Adalat, but this will not constitute for that, my lord. It is a challenge made by the petitioner in response of an IA granted, temporary relief granted. So it may be posted to 4th, my lord. List number 3, serial number 48.
No, if it is for IA, it cannot be settled.
No, my lord, it was by virtue of a Supreme Court direction, my lord. The Supreme Court granted the divorce, which was challenged. And the Supreme Court informed that for the maintenance purpose, you can file a petition separately. I filed a maintenance petition. I am a resident of Bangalore, my lord. The properties are in Mandya. Though my IA number 1 was against not to alienate until passing of this judgment on 25. But that was
We'll
challenged.
call this matter next week.
Please, 4th.
Serial number
48, my lord. Release 3, 48.
list next week.
Much.
Yes.
Yes. Therefore, appellant counsel appeal is by the insurer challenging the liability.
Issue notice. Pending. No delay. There shall be stay. Order. Dated 16/10/24. MVC 817 of 23. Asked by the first additional senior civil judge, additional MSCT number 4 at Chitradurga. Subject to appellant depositing 50% of the what is the amount?
What is 50? That is on liability. There is a time barred claim petition which was entertained and adjudicated in spite of my objection.
Now, what is the award amount, sir?
50,000.
So when is the order judgment?
Order.
Judgment date?
Dated 16th October 24.
How your appeal is maintainable?
Maintainable because it's a question of liability, my lord. It is liability and
Please
the
show
claim
me.
petition itself is barred by limitation.
No.
We are that issue has not been adjudicated upon, and the liability is fastened.
No, in view of section 173.
173, there's an embargo that.
So you have to satisfy how you will overcome that embargo.
I'll do it.
And you cannot do it because that is 50,000. Even if your statement is that it is going to be on liability, there is no such distinction made in 173.
Then the insurer would be been any aggrieved party would be.
None of you can do it.
No, that's not the intention. I'll just see
173 Kodi.
No, 173. I'm conscious of that.
1 lakh. Now
That's
it is
true.
amended.
I'm not on that point.
Before 2022, it was 10,000.
Yes.
Now it is 1 lakh.
Yes, ma'am.
So that is very clear.
There is no distinction. There, the 173 only speaks of the amount, the award amount.
And
No
this
appeal
one shall lie against any award of claims tribunal if the amount in dispute in appeal is less than 1 lakh.
I'll just place some decisions in this regard and also
Cancel that order. Call this matter next week at request of appellant.
this before the appellant counsel. This is an appeal by the insurer challenging the liability. The premium check issued by the owner of the vehicle had bounced much before the accident. We have intimated, but the MSCT has misconstrued and fastened liability, directed us to satisfy the award.
Idra list ide.
2 lakhs.
or issue notice to respondents. Orders on IA. That shall be stay. Order dated 29/11/24, MVC 593 of 22 by the Principal Small Causes Senior Civil Judge MECT Mysore, subject to appellant depositing 50% of the award amount before this court within 4 weeks from today. Is there any sharing or entire liability on you?
Entire liability is upon.
Jay Kumar.
Lord, this appeal is by the insurance company challenging negligence and quantum of compensation. I am ready to deposit 50% of the award amount.
Stay.
Before High Court.
Dated 4/1/25, MVC 1149 of 19, passed by the Senior Civil Judge MECT Nanjangud, subject to appellant depositing 50% of the award amount before this court within 4 weeks from today. Upon such a deposit, the amount shall be kept in FD in a nationalized bank.
Until further
orders.
Post along with the connected appeal 1726/25.
All along with MFA.
1726/25.
Yes.
Much obliged.
Insurance company appeal.
Issue notice
On
stay.
the ground of liability, my lord. Non-involvement of the insured vehicle.
Order dated 7/2/25, MVC 3450 of 20 by the third additional judge, MECT Court of Small Causes, Bengaluru, subject to the appellant depositing 50% of the award amount within 4 weeks from today before the
High
Court.
Yes.
Upon such deposit, the amount shall be kept in FD in a nationalized bank until further ordered. Notice to R2 dispensed. About R1? Issue notice to R1.
This is also connected, my lord.
Same, huh?
Yes, my lord.
Same MVC?
Very MVC. Connected matter.
Connected under same accident.
Arising out of the same accident. MVC 3449 of 20.
Issue notice stay 7/2/25, MVC 3449 up to 2020. Court of Small Causes, Bengaluru, MECT, subject to appellant depositing 50% of the award amount. Before this court within 4 weeks from today.
Obliged.
For the
petitioner. The two matters, 21797 before my lords. I have filed this petition on behalf of the husband. It has a long and a checkered career. I'll just make a mention without reference to this record. After about 10 years of marriage, my lord.
Your friend is not here.
My lord,
Your
ಅವರು VC I can see his name on the VC. If my lord.
My lord, appearing for plaintiff petitioner, my lord.
Yes.
If I can, before taking my lord to any of these.
Yes.
2009, the marriage takes place. Both of them are from Varanasi.
20.
2020, my lord, after a period of 11 years, they get a female child. Both of them are working. Both of them are in the IT field. They were residing in the house that was purchased by the husband. Now the husband is sent out, and the daughter, minor daughter, and the lady is staying in the house. Now the problem arose because there were some various.
Mr. Counsel, Omran.
So I pray for time, my lord. My senior is not
You
well.
must mute your system. Your system is disturbing the court. When you are asked to answer, that time you can unmute. Mute Madi. You are
Thank you,
disturbing the
ma'am.
court. He's not arguing, so he's only just briefing. We'll give you time.
The differences between the husband and wife became so enlarged that the husband knocked the doors of the court as a GNW. Then there was a consent order where I would like to take my lord's kind attention to my writ petition, because they concede that I am also entitled for visitation rights. After all that I am seeking now is a visitation rights. There are umpteen number of orders now by this honorable court and the apex court regarding the rights of the child rather than recognizing the right of the parents. Kindly now may I request my lord to see ink page 104. That's the order sheet.
That's the impugned order?
Impugned order, that's not the impugned order. This is the order sheet.
Now, what is it that you're seeking here now?
Now, what I'm seeking is there was a repeated violation of the order passed by the trial court, for which I made an application saying that I want the custody of the child, for which the trial court refused. They agreed by that I am before this court. I am only trying to bring down the basic facts, saying that they consented all along, but they are violating. May I request my lord to kindly see ink page 104. ನಾನು ಜಾಸ್ತಿ ಹೇಳೋದು ಬರೀ ಎಷ್ಟೆಷ್ಟು ಬೇಕೋ ಅಷ್ಟು ಮಾತ್ರ ರೆಲೆವೆಂಟ್ ಪೋರ್ಷನ್. I will not read anything.
Yes.
104, my lord.
Yes,
Last one. That is order sheet dated 29/1/2022.
Yes.
Line 3. A respondent is hereby directed to permit the petitioner to video call to her, talk with child. This was on and off given, not properly seen. Kindly seeing page 106. Case called out, both counsels are present. Respondent is hereby directed to permit the video call of the petitioner to talk with the child on every Saturday and Sunday for 1 hour. She blocked us.
No interim order was passed by then.
ಇಲ್ಲ ಇನ್ನು ಮಾಡಲಿಲ್ಲ ಅವಾಗ. Then ink page 107 para 2 line 4. During the course of argument, counsel for the respondent submitted that respondent has no objection to grant visitation rights to the petitioner, but the honorable court may please to permit the respondent supervise the petitioner with his child with her vicinity. That was on and off, that was given. Then the court passed an order. Ink page 139. I'll only take my lord to the final orders. This order was violated. 139.
Yes.
Line 4. Read with section 10 of the Family Courts Act is hereby partly allowed. Petitioner is granted interim custody of the child on every Saturday from 12 noon to 2 p.m. and for 4 hours on festival days, Dasara, Diwali, Christmas, Ugadi, Holi, Gauri, Ganesh Chaturthi, and for 4 hours on birthday of the child, that is on 28th September. This is not being complied till today. Since this was not complied, what necessitated me was to make an application which resulted in the impugned order at ink page 33 annexure A. In between this time, there are umpteen number of complaints by both sides to the police. She filed a DV case. She also filed a 498A. This honorable court has squashed 498A. This honorable court has also squashed DV case with respect to my parents and cousin, and only retained so far as I am concerned.
Application for handing over and compliance of the order.
Non-compliance of the order.
Rejected.
Rejected. I'll be satisfied if the child is given to me. And the defense that they take is that the child is autistic and it is not well. Then there was mediations that went on before this honorable court.
How old
And
is the child?
is about 5 years now.
Female child.
Female child. So it will take a long duration for me to establish that I am a better parent and to get the complete custody. Till such time, it is the right of the child that requires to be recognized. I live with my parents here in Bangalore. My lord, kindly see the court's order.
Where is the respondent staying? Where is the respondent staying, sir?
Electronic City. Both of them
in Bangalore?
Bangalore. Both of them live in Electronic City, maybe about 2 kilometers away from each other. Kindly see the order dated 13/12/23, my lord.
Of this court?
Yes, my lord.
Where is your application which you filed for interim custody on which the first order was passed?
Yes. ಇದಕ್ಕೆ ಮುಂಚೆ ಅಯ್ಯೋ ಒಂದಲ್ವಾ ಇದು ಮುಂಚೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಫಿಸಿಕಲ್ ಇದು ಬೇರೆ ಅಯ್ಯೋ ಒಂದ್ ತೆಗಿ ಇಟ್ಕೊಂಡು ಮೇ ರೀಡ್ ಮೇಲ ಮೈ ಲಾರ್ಡ್ಸ್ ದಿಸ್ ಕೋರ್ಟ್ಸ್ ಆರ್ಡರ್ 13/12/23.
Yes, yes.
The issue is with regard to abiding of the order visitation by the wife in favor of the husband. Though the wife seeks modification of the impugned order of visitation pending for such modification, if any, it is made clear that if the wife does not abide by the order of visitation that is passed by the concerned court, unless it is stayed or modified by this court, the matter would be viewed seriously, and the wife would also run the risk of shifting the custody of the child for blatantly violating the orders of the court, as the allegation of the respondent father is that the petitioner wife is not abiding the orders as is granted by the concerned court. Visitation as granted by the concerned court shall be permitted by the petitioner wife and continue to be permitted till the modification would be considered in the subject petition. Learned senior counsel petitioner submits that the child is now
Not the petitioner, you're the petitioner, not the wife here.
if there are two, they have filed one petition.
All right.
So my lord has
So in that case, the other case filed by the wife.
wife
is
that
for
is that's
modification.
Yes, madam.
Of which order?
Of the same order that I am mentioning.
Impugned order.
Yes, madam.
Impugned order is rejected.
The first one, IA1, where I was given liberty to see the child.
Order in your case is your application which is rejected.
Yes, madam.
So her petition may be the first order.
First IA1.
Yes.
My lord directed me to show the IA.
Yes.
It is at ink page 56.
ಏನ್ ಕೇಳಿದ್ದೀರಾ ಅದರಲ್ಲಿ?
ನನ್ನ ಕೇಸಲ್ಲಿ
50?
56.
Read it. What is the prayer?
Honorable court be pleased to grant visitation rights of the child to the petitioner as sought hereunder in the ends of justice. To grant interim custody of the child on every Saturday at 12 noon till 2 p.m. To grant interim custody of the child to the petitioner for 4 hours on festivals such as Dasara, Diwali, Christmas, Ugadi, Holi, Ganesh Chaturthi. To grant interim custody of the child on 28th September of every year, the birthday of the child. To grant interim custody on 1 day in a month for complete overnight custody. Permit the petitioner take the child to meet his parents who are residing in Bangalore, granting him the custody between 12 noon to 5 p.m. on 4th Saturday. All reasonable demands that the husband has made, and both of them live in Bangalore. And she filed a petition. She had filed a DB 498A. She went to Supreme Court seeking for transfer of only this petition. Supreme Court rejected that transfer petition. Date ಕೊಡು, ಇದು ಕೊಡು. ಏನ್ ಮಾಡಮ್ಮ? ಏನು ಲೋಕೇಶ್? ಇಷ್ಟು ಹಿಂಸೆ ಮಾಡು.
The child is an autistic child?
No, man, we don't admit that. It has got, that's the reason why this honorable court repeatedly asked the other side to bring the child before the court. And we also said that we'll participate, we'll take the child together to the hospital if it is required, at my expense.
When did you separate from each other?
Of 2020. 20. 20. Madam.
And 21 is the
Yes, madam.
petition filed.
And too many complaints are filed against each other at Varanasi, here, every second day. And we have also made an allegation that her brother is a lawyer practicing in Delhi, and she is instigated also by him. We have gone on record saying that.
So you are now residing in Bangalore?
Yes, my lord.
Yes, Mr. Omaran.
Yes, my lord.
Yes, what do you say?
So my lord is now, my senior is not available for 2 weeks. The praise for time.
Is not available for?
2 weeks. He's suffering for 2
weeks.
Yes.
When is the vacation? School, child is going to school?
It is just going to ಇದು ಅದೇನಂತಾರೆ
Free. Free nursery.
ಎಲ್ಲಿಗೂ ಕಳಿಸ್ತಾ ಇಲ್ಲ ಅವ್ರು ಮನೆಯಲ್ಲಿ
ಮನೆಯಲ್ಲೇ
ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇದೆ.
ಆಮೇಲೆ ಏನಾಗುತ್ತೆ ಇನ್ನೊಂದು ಪಾಯಿಂಟ್ ಯಾವುದೇ ಫೆಸ್ಟಿವಲ್ ಇದ್ರೂ ಫೆಸ್ಟಿವಲ್ ಹಿಂದಿನ ದಿನ ಊರಾಚೆ ತಗೊಂಡ್ಬಿಡೋದು, ಚೈಲ್ಡ್ ಇಸ್ ನಾಟ್ ವಿತ್ ಮೀ, ವಿ ಆರ್ ಟ್ರಾವೆಲಿಂಗ್ ಅನ್ನೋದು, ಮೇಲ್ಸ್ ಹಾಕ್ಬಿಡೋದು. ಆಮೇಲೆ ಬರ್ಡೇ 28th of September ಆ ಮಗು ಬರ್ಡೇ, ವಿ ಡೋಂಟ್ ಹ್ಯಾವ್ ದ ಆಪರ್ಚುನಿಟಿ ಆಫ್ ಬೀಯಿಂಗ್ ವಿತ್ ದ ಚೈಲ್ಡ್. And Holi, Christmas, Diwali, whatever holiday, we don't get this. And for everything, she is very quick in communicating. She says, I am going out of town. There is an order that before, without taking permission of the court, she cannot leave the jurisdiction. She doesn't care. Whenever she wants to go, she goes to Delhi, Varanasi, wherever it is. I am left in lurch. There has to be some kind of a fetters also to the rights of a mother, because ignoring the rights of a father, ultimately it's the right of the child.
Correct. When you already have orders, you go and execute it.
ಇದೇನು ಹೆಂಗಾಗುತ್ತೆ ಗೊತ್ತಾ ಸಮಯ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡು my lord has long and rich experience in this. My lord knows how difficult it is for a man to get this. What I'm just saying is,
no, if there's a violation, file contempt. Court will take action.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪರ್ಸನಲ್ ಆಗಿ ಕೇಳಿದ್ರು ಒಂದೊಂದು ಡೇಟ್ ಇಟ್ ವಿಲ್ ಗೋ ಫಾರ್ 6. ಏನ್ ಕೇಳಿದ್ರು ಕೊಡೋದಿಲ್ಲ, ಡೇಟ್ಸ್ ಹಾಲಿಡೇಸ್ ಅಲ್ಲಿ ಕೊಡ್ತಾ ಇಲ್ಲ. ಮಗು ಹುಟ್ಟುಹಬ್ಬದ ದಿನ.
That is why I asked you to read your application prayers.
I did read.
Yes, you have not even sought for custody during vacation.
ಅಲ್ಲಿ ಒಂದೇ ದಿನ ಕೇಳಿದೀನಿ ನಾನು.
ಸಾಕು ನಿಮಗೆ ಅಷ್ಟು, ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ, I will be satisfied if this happens. I'll be satisfied. ಅದೇ ಕೊಡ್ತಾ ಇಲ್ಲ. I am not even given a entry there.
All right. Yes, Mr. Omran, keep the child present and the mother on the next date of hearing. Right. What is today's date? First, Friday. Keep the child present on Friday.
Good.
Understand? Mr.
My lord, senior not there. Okay.
Huh?
Okay, ma'am.
Senior ಅಲ್ಲೇ ಇದ್ಕೊಂಡು ಓಕೆ ಅಂತೀರಲ್ರಿ?
Senior is not there, my lord.
ಮತ್ತೆ ಓಕೆ ಅಂತ ಹೆಂಗ್ ಹೇಳಿದ್ರಿ?
Friday. You told Friday, no, my lord.
Friday ಬನ್ನಿ, ನಿಮ್ ಸೀನಿಯರು, ನೀವು, ಕ್ಲೈಂಟ್ ಮತ್ತೆ ಮಗು ಕರ್ಕೊಂಬನ್ನಿ.
Yes, my lord. Yes.
Counsel for petitioner is present. Counsel for the father, Sri H. Ravishankar is present. Learned counsel for the mother. What is your name, Mr. Counsel? Varun. What is your name?
Gautam.
Gautam, on behalf of Omran Khan, is present for the other. Both the learned counsels are directed to keep their respective parties present before the court. The mother is directed to keep the minor child present before the court at 4 p.m. on 4th Friday, 4th April, Friday, 4 p.m.
Okay, my lord. Thank you, ma'am.
Great.
There is Pradeep, please. He comes with the very same story. ಏನಾರು ಸಿಕ್ಕಿದೇನ್ರಿ?
Even one letter, Director of Prosecution, ಅದು ಓದ್ತೀನಿ ಸ್ವಾಮಿ.
ನೋಡಿ.
Last paragraph.
ಏನ್ ಕಾಪಿ?
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ. ನೀವೇ ಬರ್ದಿರೋ ಲೆಟರ್ ಇದು? ನೀವು ಬರ್ದಿರೋ ಲೆಟರ್?
ಲಾಸ್ಟ್ ಫೆಬ್ರವರಿಯಲ್ಲಿ ಕೊಟ್ಟಿದ್ದವರು ಮತ್ತೆ ಬಂದೇ ಇಲ್ಲ ಅವರು. ಮೇಲ್ಕಂಡ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಕರಣ ಮತ್ತು ಪ್ರತಿ ಪ್ರಕರಣವಾಗಿದ್ದು, ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ವಿಶೇಷ ಸರ್ಕಾರಿ ಅಭಿಯೋಜಕರುಗಳನ್ನು ನೇಮಿಸಿದ ಆದೇಶದ ಪ್ರತಿಯನ್ನು ಇದರೊಂದಿಗೆ ಲಗತ್ತಿಸಲಾಗಿದ್ದು, ಸದರಿ ಪ್ರತಿಯನ್ನು ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಲು ಕೋರಲಾಗಿದೆ. ಹಾಗೂ ಸದರಿ ಪ್ರತಿ ಪ್ರಕರಣದಲ್ಲಿ ಈ ಹಿಂದೆ ಕಾಲಕಾಲಕ್ಕೆ 3 ಜನ ಸಹಾಯಕ ಸರ್ಕಾರಿ ಅಭಿಯೋಜಕರು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿರುವುದು ಕಂಡು ಬಂದಿದ್ದು, ಸದರಿ ಮಾಹಿತಿಯನ್ನು ಸಂಬಂಧಪಟ್ಟವರಿಂದ ಪಡೆದು ಮುಂದಿನ ದಿನದಲ್ಲಿ ಸಲ್ಲಿಸಲಾಗುವುದೆಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. So they are asking time. They are not specific still who conducted the case and counter case.
So this is vague again.
Right.
It was a specific order by me that you have to ascertain whether the PP who conducted the case is the very same person in both the cases or not. Simple order.
Yes,
if it is different person, you give the name and say there were 2 different persons. This is the name of that person in the first case. This is the name of the PP in the second case.
Still they want to on time for ascertain.
This is unnecessarily dragging the matter with. How can this be take such a long time?
Because of, this is very old matter.
Lord,
Even
and further, I also verified from the, the records of the trial court. Lord, there is no specific order from the trial court with regard to, Lord, there is not the change of PP in respect of both the cases. There is no specific order at all. If there is not such kind of orders are placed before the trial court, there would have been some orders from the trial court that our PPs are not special PPs are not appointed in so far as cases are concerned.
But still they were.
See, this matter was reserved.
Yes, ma'am.
At your request, I opened it.
Yes.
Because you said that
Please.
there are two different PPs.
Yes, ma'am.
But again, you are dragging on the matter without furnishing
No,
the
my
relevant
lord,
detail.
This is what the director of prosecution given the letter.
All right, because this letter has come, I will grant you one more week.
Please, ma'am.
If it doesn't come by that date,
Please.
I will pass orders, that's all.
Please, ma'am.
Lord, it's not sufficient, mere appointing PPs. They have to place before the trial court,
Not
please.
appointing. He has to place before the court that the case was conducted by two different PPs,
Please,
not
please.
mere appointment.
Please, Lord.
Mere appointment, but you conduct the same case, standing here sometime, standing there sometime.
Please.
Is not going to be sufficient. Criminal prosecution.
As per the director of prosecution, there are different prosecutors conducted.
Did you understand what he said?
Yes, sir. Yes.
Even if the director of prosecution has appointed two different PPs,
Yes.
but you conduct as Mr. Lakshman,
Yes.
appearing for complainant in one case, accused
In another.
in the same case, then you are running contrary and you are fighting your own self with one sword and two swords in both the hands, cutting yourself. That is what is the crux of the matter.
Please, Lord, sum and substance.
Which is prohibited in law.
1 week time may be given.
So you have to fight with somebody else, not by yourself with holding two hands and yourself. That's his only argument.
1 week time may be given.
Learned counsel, for counsel for the petitioner is present. Learned counsel Sri HCGP, na? You are HCG, learned HCGP Sri Lakshman.
Yes.
I am right in remembering your name.
Yes.
Sri Lakshman files a memo along with a letter written by the director of prosecution.
Yes.
Dated 12/2/2025. Based on this letter, he seeks a week's accommodation to ascertain whether a case conducted on behalf of the prosecution is the very same public prosecutor for both the cases or two different public prosecutor for both the cases.
Yes.
List this matter on. Wait, could you?
The 16th or 17th.
All right. Call on 17th.
Please, please.
Sorry for the interruption, Manoj. Third list, 46th matter, Manoj. The matter has become infructuous. I'm filing a memo for the withdrawal. 46th, third list, matter. Yes, this writ petition was filed challenging order dated 23/2/2021. In a MC petition, subsequent to that MC petition, we had filed a MFA, which was compromised on 17/12/24. Hence, we are withdrawing this writ petition. The permanent alimony has been
You
given.
want to withdraw this petition?
Yes.
You have said settled out of court. So not withdrawal, you want disposal of this.
No, my lords,
On the ground
we
of
have
settlement.
settled in an MFA. The divorce has been granted.
Learned counsel for the petitioner files a memo. Memo reads as under. Placing the memo on submission of learned counsel for the petitioner, this petition is disposed as having settled, and hence the same stands. And in view of the same, the petition is infructuous, disposed of as, dismissed as having become infructuous.
Obliged.
Appearing for the petitioner side, kindly pass over my.
Ready na ನೀವು?
Claim petition dismiss ಆಗಿದೆ ಅವ್ರದ್ದು WC. It takes some time.
It's going to come
Next week.
So no relationship of employer-employee.
Here, the death has no nexus to the nature of employment. He goes to a different place at Kerala, stays for 2 days, and there he dies. Of course, in the cabin of the lorry. But it is found out by the honorable court that he was just sleeping at this stress, and he had a heart ailment prior to this incident. That he was a heart patient.
Records are here.
Records records better.
Jagadish Baliga. We'll have it next week. At request of learned counsel for the appellant. List this matter next week. Counsel for respondent 2 is present. Yes, madam.
Yes, Your Lordship. Can I take a couple of minutes before taking adjournment in this matter, Your Lordship? There were 4 petitions pertaining to the same accident. 3 claim petitions were filed in the Andhra Pradesh Hindupur, Your Lordship. The claim petitions have been dismissed. The insurance company has been exonerated. So finding that, 1 petition has been filed in Karnataka, only to avoid that dismissal, Your Lordship.
So after the dismissal.
Yes, I suppose because I have sought the order
Can
copies.
they file after the petition being dismissed? Claim petition.
The different claim petition, Your Lordship. Different claim petitions. Out
Correct,
of 4,
but,
2 were filed there.
Wouldn't it be barred by time if he files
I'm
after
not,
the?
Your Lordship, my humble submission, I'm not on that, Your Lordship. My only submission is that I have sought for the order copies from Andhra Pradesh, Hindupur. Instead of sending the certified copies, they have sent the Xerox copies. So for that, Your Lordship, I request this
Learned
honorable
counsel
court
for the
to give me
appellant seeks
10
time.
days time.
Call after 10 days. Date code. Hmm. 15th, madam, 16th could be, because 15th mostly all these criminal matters will come.
So 16th, I have some
17th.
matters. 7 after 20th, any date here.
15th. Oh, correct. But that will be only in the afternoon.
After 20th, any date is possible, Your Lordship.
All right, take it on 25th.
Obliged, Your Lordship.
Yes, Mr. Dabali.
Nobody is coming. None appears. Call next week.
Appearing for the petition appellant on the last date of hearing, you will recollect.
Yes, Mr. Amit Anand.
Yes, sir.
Egade avaru idralla online.
In this matter, the liability of the insurance company has been exonerated, and the claimants have also filed an appeal before this honorable court. Next matter.
Elli Suresh.
My lord, sir, my humble submission is, since the day I filed this appeal, though they have filed wakalat in this matter way back on 29/8/2024, they have not even appeared once in this matter. They are not interested in this because they are only interested in taking money from the insurance company. And my contention is very short, that neither I was the owner as on the date of the accident, and so the liability could not have been fastened upon me. That is my short submission that I made last time, and I gave the case laws of.
Decided by the court, na?
Yes, it's a Supreme Court judgment, landmark judgment.
All right, I am ready to hear you. Where is
I will make my submission, very short submissions.
Where is your opponent who is going to oppose you?
He is
only an insurance company.
He is the insurance company, and the claimant.
So liability is fixed on not him.
Not on.
He has to pay, and once he pays the insurance company to the claimant, he has got rights to recover from me. That's my grievance before this court, that it cannot, he cannot recover from me.
I am not going to ask him to pay first of all. I am going to direct you to pay straight away.
Cannot be, my lord, in my view.
I'm not going to ask him when you're here.
No, is whether he has paid or not. In fact, on the last date,
It is something like this, where principal borrower comes and says, now you take it from the guarantor.
Illa, it is not like that,
Yes, it
sir.
is like that.
I'm not the owner.
This court is not going to allow such things, and straight away directed the owner to pay instead of pay and recover. The
But
pay
who
and
is the
recover,
owner is the question.
That we will decide.
Yeah, Madana.
That I will decide.
I will assess
To oppose you, the other side has to be here.
No, my only humble submission is now.
So some amount is ordered now.
Yes, some amount. The amount is.
So now the question is whether who's the other owner according to you?
Anand Kumar, R2, my lord.
In your case?
He was the, not according to me, it's a matter of record that he is the owner.
R2.
R2.
So he is not before the court?
Several summons were taken, paper publication, substituted services, all that is done, man. Everything is done in that.
So he had participated before the tribunal?
Tribunal Jote, what he did, he just files wakalat. Thereafter disappears. No objections, no evidence, nothing. That is the whole thing.
You contest.
I filed my objections. I produced the photocopy what I had. And the issues, as sir, you will recollect that there were no issues on the owners. But I had produced certain documents. In fact, the review was filed when again opportunity was given. But the tribunal said that I don't have powers to review.
All right.
Therefore, I am before you.
In case Mr. Hegde,
Yes.
I agree with him. If this court were to, there are two situations that can arise. You are not anyway in appeal.
Yes, madam.
The situation is
And
because
pay and recovery order agide.
Because pay and recovery order agide.
Yes.
Nimmeli.
Yes.
You are not challenged that.
We have just we are not challenged. We are not challenged.
As of now, it is not.
We are
there.
not challenged.
So, though there is a pay and recovery, madam, in that 230 matters, any Suresh is also there, any case? No. So, in this two cases which are before the court,
yes,
one is by
the
so-called
owner, no,
not so.
Seller of the vehicle.
You are the original owner.
I was the original owner. That's the point.
Original owner.
But not the owner on the date of accident.
Original owner. And the other one is by the claimant.
Yes, sir.
So you are not in appeal. So claimant is seeking enhancement.
Yes.
He is seeking to absolve himself.
Yes, sir.
And fix the liability on R2.
Yes.
R2 is not here before the court, though he is served.
Yes.
Served and.
All right. If the liability fixed on him is shifted
Absolved.
to R2,
yes,
then pay and recovery, you will have to bear it.
Yeah.
And recover it from R2.
Yes.
Then recovery from Melody, if that is so, recovery from the
R2.
R2 only.
That would be correct, Your Honor.
Means Melody, he is to prove Melody whether as on the date of the accident.
I will.
That is on
Sir, one
merits.
nimsham, sir, one nimsham. As on the date of the accident, whether he was the owner or not, whether RC book stands in his name or not. Because Supreme Court judgment, as your lordship is aware, my lord, Supreme Court judgment says, unless the RC is changed, he remains the owner of the.
I'll hear you.
Yes.
When I hear on merits.
It requires some consideration, my lord.
I will hear you, give you all consideration. The question is now whether we have to now also wait for Suresh.
Yes. I will inform Suresh, my lord.
In his absence, I cannot dismiss or.
And his claim
reject
also there, my lord, for
reject his claim for enhancement. So we'll give one more opportunity. If he doesn't come,
we'll just
hold it that this court.
We'll assist this honorable court and my lord.
Even if there is slight modification or enhancement which calls
But
for.
thing is, my lord, even I think my learned friend doesn't dispute that RC book stands as on the date of the accident, in whose name it is to be looked into.
My lord,
he says some sale receipt, etc. is there.
No.
Sir, one
that won't be correct.
sale receipt and other things he is relying on, if I am right. But the thing is, my lord, the Supreme Court judgment clearly speaks. My lord, if the RC stands in the name of this one, then my lord, in two judgments, my lord, what the Supreme Court has stated is both are jointly and severally liable. That transferor and transferee. That's why the judgment of the tribunal may seems to be right. And even if I'm right, my lord.
Which is this Supreme Court judgment?
my
This
lord,
was
two,
relied.
Pardon, my lord.
This judgment was relied before the tribunal.
I don't think, my lord.
May I make my submission? Firstly, I have not said anything what my learned friend is saying. And I'm speaking from the records. My lord, have a look at the cause list for the day. MFA in this memo dated 12/9/2023 filed by advocate for the appellant admitted. My lord, please take that memo. In that memo, the B extract is produced of the vehicle. My humble submission on the last day also was, as on the date of accident, I was not the owner. This document was produced before the court. This document
Tribunal,
was admitted.
tribunal. You produced this before
Yes, and it is admitted.
Marked
This is
as
shown.
exhibit.
It is not marked. It is admitted, my lord.
It is not marked as an exhibit.
It was produced before this court. It is not marked as this court.
How I asked you a simple question whether it was produced before the tribunal.
Not before the tribunal, before this court, and it was admitted.
All right. How you expect the tribunal to pass an order when the
That is why I'm on appeal. Tribunal said that I don't have powers to review. So the matter was shut there. So I'm before. Now the only thing is I am not making a false submission on the face of it that I am producing sales receipt. No. I'm not doing that. I'm establishing the fact that I was not the owner on the day of accident. If I prove that,
sir, that he does not know.
He knows. He's come to the court without file, unfortunately.
No, not now. Whether you produce this document before the tribunal or here.
It is all produced and given to him. Unfortunately, my friend is not carrying the file. What do I do? So
no, it was produced before this court.
Yes, and he's a party. He's been served.
You served a copy,
Yes.
Mr. Hegde.
Just I will check it up, my lord. Usually.
So I cannot help him.
If it is directed to take notice, my lord, usually we will send, my lord, all papers to company. And my lord, if it is direct sent from them, they must have all these records, and I will just check it up and make submission. Because this is not just like, my lord, this.
Let's not make a wrong submission before this court.
Question is, my lord, regarding the liability question. So this we will look into, and
now that he has produced B extract,
yes,
matter.
Even if R2S2 after selling and receiving, not after selling, after purchasing.
But if his name disappears and the other person's name appears as on the date of the accident, then policy stands in whose name it is to be looked into.
That's all.
And whether he has made an application for transfer of the insurance policy in his name is also to be looked into. These are all the questions.
The law.
Insurance runs with the person or insurance runs with the vehicle?
Vehicle anta judgment is there. But as per the Motor Vehicles Act, my lord, section 157, necessarily the transfer is also given notice to the
insurance. Fundamental rule is insurance always runs.
No, ultimately, my lord, this
Right, my lord.
for the purpose of recovery also, my lord, whether such thing has been done or not as per the law.
Learned counsel for the appellant Amit Anand is present, along with learned counsel Shri S.V. Hegde Mulkhand for respondent number 1 insurance company. There is no representation on behalf of the claimant, who has also filed an appeal. Time and again it is seen that there is no representation on behalf of the claimant. In case the claimant doesn't appear, make his representation and argue the matter on the next date of hearing, this court would proceed to pass orders on the basis of materials available on record. Hence, another opportunity is provided to the claimant to make his representation. Call this matter on.
My lord, one submission before. On 19/12, this honorable court had passed an order against the insurance company not to take any persuasive action to recover any amount from me. That has to continue, because time and again the matter is getting.
So the interim order has to be continued.
Yes, ma'am.
Interim order to continue till next date of hearing. Call on.
If 9.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ Mr. Hegde?
But now vacation is approaching.
Vacation ಬರ್ತದೆ ಹೋಗುತ್ತೆ.
Any
After one
time,
vacation,
Lord,
another
you
vacation
may.
will come. And we can go
Any
on.
day, my lord, after. May I request, my lord, my learned friend.
My lord.
One nimsham. Request my learned friend to give one set of copies so that easily facilitates, my lord.
I'm here to facilitate and do everything possible so that you don't take adjournment.
I am not taking adjournment because regularly we are
Mr. Amit Anand,
regularly we are
there are very seasoned advocates appearing before this court. Since how many years you are practicing?
15 years, my lord.
What is your age?
40.
He must be practicing for 40 years.
Certainly.
ಎಷ್ಟು ಹೆಗಡೆ ನಿಮ್ದು ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
ನಾನು 1980 ಎಂಡಲ್ಲಿ ಎನ್ರೋಲ್ ಮಾಡಿರೋದು.
So there are some advocates who don't come here to take adjournment unless there is some genuine reason.
But I think my lord will recollect
No.
the fact that you had asked him to come prepared. He has come to the court without file.
No problem. We don't know what happens. It is kept somewhere, kept in the car. You keep somewhere filed here and somebody takes it and goes.
In fact, my lord had cracked a nice joke on the last day that I'll give you a date on 1st, provided you don't make me a fool. That was the joke of that day.
So now he has fooled you.
Now I'm available today.
I have got to in the lighter vein. I have brought the file, but it's a different file.
I'm so sorry. We can't fool you, but everyone can fool you.
Say that I didn't bring any
Has
file.
proved, my lord.
Don't say that I didn't bring file.
That Mr. Hegde should not fool you.
I'm fooled, my lord, today. At least I'm happy about it.
All right. List on date 15th, 16th. 15th, 16th, Madi, on that day only it can be disposed of.
Yes, my lord.
One set, my lord.
I will direct learned
Yes.
counsel for the appellant Sri Amit Anand to facilitate one copy of the appeal memo along with documents placed before this court to learned counsel
Yes, my lord.
SV Hegde in advance.
ಈಗ
ಇವತ್ತೇ ಕೊಟ್ಬಿಡಿ.
ಈಗ
22nd ಈ ತರ ಏನಾರ ಹಾಕೋಬಹುದಾ? 22nd ಗೆ.
If 16th, my friend can accommodate my request.
I definitely will do it.
No, I may not be here on that.
Any day.
Much obliged, sir.
So that's why I'm giving on 16th. You can argue on the same day. It can be disposed.
Certainly, ma'am.
So don't fool him next time again.
Your last may kindly make it 17th, my lord. 17th.
All right, 17th.
Okay.
17th.
Thank you, sir.
To the second respondent in this case, your lordship, there is no liability fastened to the insurance company and the ground that that was an act policy. But in this case, your lordship, I could see that though the insurance company has taken the contention of act policy in the written statement, as well they have led the evidence, but nothing is forthcoming from the judgment of the tribunal about marking of that document, your lordship. I just would like to clarify once with the court file, if your lordship permits, the TCR. And also, if it is not there, since it's a question of law, your lordship, I may kindly be permitted to produce the policy copy by next date of hearing, your lordship.
Petition is dismissed as against second respondent.
Yes, your insurance company, because it was an act policy and the inmate of the jeep were one of this petitioner was the inmate of the jeep. Some 9 to 10
now fastened with the liability?
The owner, your lordship, owner and driver both, your lordship.
Liable to pay compensation. Third respondent.
Yes, your lordship. Third respondent is the owner.
Act policy.
Yes, your lordship.
So act policy alli nimdu pay and recovery baradilla.
Illa sir, barodilla.
So that's why you have been absolved.
Yes, your lordship.
So what is that you want to see here now?
That policy copy, about having produced that policy copy, it is not forthcoming from the judgment, your lordship, as exhibit R1 or something of that sort. So I just would like to see the TCR, your lordship. If it is not there, I may be permitted to file it, the copy of the policy, because it has not been denied by the petitioners that it was not an act policy and that they have not denied it.
There is no counter appeal also?
Pardon me. Yes, your lordship.
By the owner?
Yes, your lordship. Yes, your lordship. So by next date of hearing, I'll collect the copy from the concerned this thing and produce it before this honorable court, your lordship.
Yeah, who's appearing?
The appellant advocate, he was here in the morning, your lordship.
Respondent yaar idhar?
Respondent, I didn't see your lordship.
Contesting respondent is R1 and
R3, your lordship.
Prabhavati. R3.
Yes, sir.
So she served an unrepresented.
Yes, sir.
Yuru illa.
Appellant advocate was here, Your Lordship. Since we were discussing about this issue, he said that he has got some inconvenience on my behalf. Please request the court anta helidru for adjournment.
There is no representation on behalf of appellant. Counsel for R2 seeks time to produce the policy.
Yes, Your Lordship.
Call on. Bandwara?
Yes, Your Lordship.
Next week. Okay.
Thank you. Date is given, na?
No, sir. Crime was registered against the petitioner.
What is the objections?
I have filed a petition before this honorable court for quashing. This honorable court has directed the trial court to file the discharge application within 4 weeks. That has been complied. Let me see page number 94. Page number 94. That is the order of the High Court. Let me see last page number 93. Last in the above circumstances, this petition is disposed of reserving liberty to the petitioner to move discharge application either under section 225 within period of 4 weeks. Order was passed on 5th July, and I have in accordance with law, before the trial. The learned trial judge is supposed not to insist upon personal presence of the petitioner accused if they apply for discharge until a decision thereon is taken. And all the contention of the parties are kept over. The order was passed on 5th of July, and I have filed the discharge application on 31st of July. Within 4 weeks, I have filed it.
5th of July. When did you file discharge application?
Discharge application is filed on 31/7. Till today, no objections have been filed. And now, yes, issue the warrant against all the accused to secure the custody.
All right. So now you are questioning in this petition the issuance of warrant.
Issuance of warrant from Mr. K. And earlier, when the earlier petition was there, additional SPP was also presented. Trial court here my discharge application passed on 252 as per the direction of the Senate. It's all my next.
So the earlier petition was for quashing of the FIR.
FIR.
In the meanwhile, you were given liberty to file discharge.
Discharge.
And after that, charge sheet was filed.
By the time charge sheet was filed. By the time this court passes an order, charge sheet was already
so
filed.
taking note of that,
Correct.
You was filed, asked to file for discharge.
Discharge.
You put the orders.
Your Lordship can set aside that order, my lord, and then.
Dispensation application.
ನೀವು ನೋಟಿಸ್ ತಗೊಳ್ಳಿ ಸ್ಟೇ ಮಾಡೋಣ ಲೆಟ್ ಹಿಮ್ ರೆಕ್ಟಿಫೈ ದಿಸ್ objections and produce that order. You produce a copy of the order?
No, we have filed the uploaded copy.
All right. All right. Record. Heard. Learned counsel for the petitioner. Both 1 and 2
I'll
are
take
same?
support. I'll take notice of both.
Both are same?
Yes.
Heard learned counsel for the petitioner, Sri Prasanna Deshpande. Learned additional SPP. is directed to take notice for respondent number 1. Issue notice to respondent number 2. Petitioners permitted to take out and summons to respondent number 2, bar complainant.
I'll take it for both.
Both Nivena?
I'll take it, man. Public servant.
So both 1 and 2 you will take?
I'll take it. I'll take it.
As additional SPP for 1 and 2. Registry to show name in the cost list. There are half a dozen objections raised, more than half a dozen. Petitioner to rectify the objections. In the meanwhile, the urgency expressed by the learned counsel for petitioner is that in the earlier round of litigation, he questioned the initiation of the FIR in the very same case in crime numbers 0058 of 24, registered by the Belthangadi police on the file of Principal Civil Judge JMFC Belthangadi, Dakshina Kannada, for the offences punishable under section 506, 341, 504, 143, 147, and 149 IPC. Before this court, in WP 14200 of 2024. Full stop. This court-wide order dated 5th July 2024 passed the following order. Page 93, last para. In the above circumstances, this petition is disposed of, reserving liberty so and so. Last part, contentions of the parties are kept open. Full stop. Next para. The counsel for the petitioner submits that pursuant to this, the order of the coordinate bench of this court, he filed a discharge application. He filed an application seeking discharge of the petitioner for the offences alleged herein above on 31/7/2024, well within the time ordered by this court. Objections to the said application is not filed, and the discharge application has not been disposed of yet. Under the circumstances, the question of issuing a warrant, non-bailable warrant against the petitioner accused, number 1, is illegal and is an abuse of the process of court. The order of this court, coordinate bench of this court, the application for discharge having been filed and pending adjudication is not disputed by learned additional SPP. Under the circumstances, there shall be stay of further proceedings. ಇಲ್ಲಿ ಇದೆ ನಿಮ್ಮ application for stay. ಇದರಲ್ಲೇ ಕೇಳಿದ್ದೀರಾ? There shall be stay of further proceedings in CC number 18452 of 24 on the file of 42nd Additional Chief Judicial Magistrate, in bracket Special Court, so and so. Till next date of hearing. Yes, stay up for the proceedings. Second case also same, same order. Different? Not one bari. Hand delivery permitted. (482).
Lord's, the complaint is at page 11. My lord, an incident takes place where, my lords, a lady was caught by the villagers for commission of a theft. My lord, she has been tied to the tree and she was assaulted by 5 people. Police registered a case. My lord, thereafter, on the next day, my lord, the fishermen's community, they hold a meeting. My lord, I was also invited for it. The allegation is I have justified the tying of the lady to a tree. Therefore, the allegation is I have tried to provoke the rioting and abetted the offences. The offences which were there already were over on the previous day. My lord would kindly see the paragraph 1 of the complaint at page 11.
Yes.
ದಿನಾಂಕ 18/3/2025 ಮಲ್ಪೆ ಬಂದರಿನ ಮಹಿಳೆಯನ್ನು ಮರಕ್ಕೆ ಕಟ್ಟಿ ಹಾಕಿ ಹಲ್ಲೆ ಮಾಡಿದ ದಿನಾಂಕ 19/3/25 ಮಲ್ಪೆ ಪೊಲೀಸ್ ಠಾಣೆಯ ಕ್ರೈಮ್ ನಂಬರ್ ಸೋಯನ್ಸೋದಲ್ಲಿ ಸೋಯನ್ಸೋ ಅಫೆನ್ಸ್ ಜೊತೆಗೆ ಪ್ರಕರಣ ದಾಖಲಾಗಿ ತನಿಖೆಯಲ್ಲಿ ಮೇರೆಗೆ 5 ಜನ ಆರೋಪಿಗಳನ್ನು ದಸ್ತಗಿರಿ ಮಾಡಿ ನ್ಯಾಯಾಂಗ ಬಂಧನಕ್ಕೆ ಕಳಿಸಲಾಗಿದೆ. ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಈ ಪ್ರಕರಣವನ್ನು ಶಾಂತಿ ಮತ್ತು ಸೌಹಾರ್ದತೆಯಿಂದ ಹೇಗೆ ನಿಭಾಯಿಸಬೇಕು ಹಾಗೂ ಎಲ್ಲಾ ಸಮಾಜದ ಒಳಗೊಂಡ ಮೀನುಗಾರರಿಗೆ ಬಂದೂರಲ್ಲಿ ಸಮಸ್ಯೆ ಬಗ್ಗೆ ಚರ್ಚಿಸುವಾಗಿ ಸುಲಭವಾಗಿ ಮಲ್ಪೆ ಮೀನುಗಾರರ ಸಂಘ ಹಾಗೂ ಇನ್ನಿತರ ಪ್ರಮುಖ ಮೀನುಗಾರಿಕಾ ಸಂಘಗಳು ಪ್ರತಿಭಟನಾ ಸಭೆಯನ್ನು ದಿನಾಂಕ 22/3/2025 ಮಲ್ಪೆಯ ಬಂದೂರಿನಲ್ಲಿ ಪ್ರದೇಶದಲ್ಲಿ ಹಮ್ಮಿಕೊಂಡಿರುತ್ತಾರೆ. ಈ ಸಭೆಯಲ್ಲಿ ಹಲವಾರು ಗಣ್ಯರು ಭಾಗವಹಿಸಿ ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶ ಮಾತಾಡಿ ಆ ಸಮಯದಲ್ಲಿ ಸಾರ್ವಜನಿಕರನ್ನು ಉದ್ದೇಶಿಸಿ ಮಾತನಾಡಿದ ಮಾಜಿ ಸಚಿವರಾದ ಸೋಯನ್ಸೋ, ನಮ್ಮ ಮನೆಗೆ ಕಳ್ಳರು ಬಂದರೆ ನಾವು ಏನು ಮಾಡುತ್ತೀವಿ? ಪೊಲೀಸರು ಬರುವುದಕ್ಕೆ 5-6 ತಾಸು ತಡ ಆಗಬಹುದು. ಏನು ಮಾಡುತ್ತೇವೆ? ಕಟ್ಟಿ ಹಾಕಲೇಬೇಕು, ಕಳ್ಳರನ್ನು ಕಟ್ಟಿ ಹಾಕಲೇಬೇಕು, ಮತ್ತೇನು ಮಾಡಲಿಕ್ಕೆ ಆಗುತ್ತೆ? ಏನು ಅವರಿಗೆ ಏಟು ಮಚ್ಚಿನಲ್ಲಿ ಮತ್ತು ಖಡ್ಗದಲ್ಲಿ ತಲವಾರಲ್ಲಿ ಹೊಡೆದಿರ? This is the statement he has made much 3 days later. Now the police say that I have called for a rioting and abatement of the offence. My lord, the abatement has to take place prior to my lord's commission of an offence which is already committed. 5 people were arrested.
What are the offences against you?
My lord, section 57 of the BNS and 191 and 192.
What do you know? Kodama. BNS.
BNS months.
57.
Your lordship.
57 abetting.
57 abetting of commission of an offence by a public or by more than 10 persons. Whoever abets the commission of an offence by a public generally or by any number or a class of persons exceeding 10 shall be punishable with so and so. Now the offence is completed, it's on 18th itself, even according to the contents of the complaint.
Correct. You went on 22nd.
Yes. Then, my lord, may I request your lordships kindly take 191, the rioting allegation.
Yes. 191.
191, my lord. Whoever,
Whenever.
whenever a force or a violence is used by an unlawful assembly or by any member thereof in a prosecution of a common object of such assembly, every member of such assembly will be guilty of an offence. My lord, there is no question of force or violence. The incident has already happened in 18th, even according to the contents of the complaint. Then 192, my lords, is same. Pursuant to this, 192 comes into play.
192. 192.
192, my lord.
Wantonly giving provocation.
Yes. Wantonly, malignly, or wantonly by doing anything which is illegal gives a provocation to any person intending or knowing that likely to that such provocation will cause the offence of rioting to be committed shall, if the offence of rioting to be committed in consequence of such provocation, be punishable with the imprisonment for a description which may extend up to 1 year or with fine or with both. The offences of rioting is not committed, then, my lords, for 6 months. My lord, in the present facts, my lords, I have not called anybody to indulge in violence. So just because, my lords, I made a statement, my lords, a registration of FIR does not arise. My lord, the ingredients are lapsing.
The incident, my lord, the background for this incident is that a lady alleged to have stolen some fish.
He has been caught and tied up
He's been caught
on 18th.
on 18th, tied to a tree, assaulted. It's a very bad scene, my lord.
Correct.
So as a leader, he says, we will repeat the same thing if something happens again.
It is not you invoke the correct provision against him.
No, the 91 they've invoked. 91, my lord, sorry, 57. 57 and 192, my lord.
Not stopping you from initiating action against him, but invoke the correct provision against him.
57, my lord, is under 192. Of course, my lord, 191 may not be applicable in this case. 192, my lord, is applicable.
If 191 is not applicable, automatically, my lord,
192 follows 191.
No, not necessarily, my lord, your lordship may see.
the writing definition has to be read into
No,
192.
but that is, he is giving a call. He's giving a call. The entire speech, my lord, he says, if naale matte hadru, now ade tara martivi. The lady, my lord, it's not, I'm not, he should have, all things what he required to say, that I condemn the incident in manner in which it is being done. Of course, we will have to catch hold of a thief if thief is found. But tying a lady to in a public this thing and beating them.
No, I'm not the person who is responsible for
in a
this.
2025 where we recognize.
All this is fine, but the complaint lacks the basic allegations against me. All this is fine.
You are now not on moral grounds. You have to go on the technicalities and legalities. If there is an offense made out against him, invoke the correct provision against him.
No,
I don't think
57. Your lordship may say 57. Whoever abets the commission of any offense.
By the time he gave this statement, already offense had been committed.
Correct. No, but he is saying if something happens again,
that again is a different provision.
That is what he is saying.
No doubt. Let us assume for the sake of argument that he has made such a statement.
Correct.
Whether 57, 191 and 192 is attracted here.
No, but by giving a call to public saying that we will continue to do the same thing.
I'm sorry. That is not the statement in the complaint. I don't know where my learned friend would get that repetition of an offense.
18.3 is the incident.
Correct, ma'am.
22.3
is a statement. 23, the meeting was held to condemn the 18.3 incident. Sorry, support the arrest of 18.3 incident.
Correct. On that day, he makes a statement.
In that day,
so by then the incident was already over.
That's correct, madam. What he says in that meeting is that
if again it is done, we should do one.
My lord, that is not the statement in the complaint. I'm sorry, my lords, my learned friend may not be correct. Please see the last 3 lines of the complaint, page 11.
Yes.
ಈ ಮಹಿಳೆ ಏನಾದರೂ ಆಕ್ಷೇಪಣೆ ಉಂಟಾಗಿ ಆ ಮಹಿಳೆಗೆ ಸಾರ್ವಜನಿಕರು ಕಟ್ಟಿ ಹಾಕಿ ಸಮರ್ಥನೆ ಮಾಡಿಕೊಳ್ಳುತ್ತಾ ಸಾರ್ವಜನಿಕರಿಂದ ಇಂಥ ಅಪರಾಧ ಮಾಡಿಸಲು ದುಷ್ಪ್ರೇರಣೆ ನೀಡುತ್ತಾ ದ್ವೇಷ ಭಾವನೆ. Where I have said that I am going to repeat the same thing if she does it again. I don't see, my lord, it said registration by the police officer himself. If I have said, he would have definitely included this. No, I can't be, my lord.
Anyway, the entire speech, my lord, has been recorded. I can bring the entire speech.
Good, but again, you have to examine. See, now the problem with these police is they don't know which provision to invoke.
No, but your lordship may recall one of the incident, my lord.
You cannot, and we are not going on the basis of morality or public opinion or the media.
No, we can't go down that line also.
Correct. You are an officer of a police department who knows the law. You invoke the correct provision against him.
But the 57, my lord, giving a call, abetment. In fact, my lord, your lordship may recall the incident which happened in Belgaum, my lord, the lady whose son was eloped with a girl. The lady was in the midnight, was brought to the middle of this village, tied, disrobed and tied. And this incident also is not less.
All these incidents cannot be tolerated and it should not be tolerated in a democratic setup. No doubt about it.
The petitioner should have been responsible in making a statement, because what happens, my lord, if people like the petitioner make this statement that we will do it again, is that
I'm sorry,
an ordinary person?
Where do I say that I do it again? Where do I say that complaint, my lord, should exhibit that kind of statement? It is not by some illiterate person who
You
has.
have a copy of the complaint?
I have a copy.
You go through it, you'll see what all he has made any such statement. Because he has read out the statement.
Of course, his complaint doesn't say, my lord, that I'm in agreement, my lord, it doesn't say it. But the video, my lord,
in invoking this provision, whether it is justified here for these offenses.
That can be examined, my lord. So you can come back with
take notice after that, we'll see. Heard learned counsel for the petitioner Shri Venkatesh Dalwai. In Mr. Dalwai Venkatesha, Venkatesh Dalwai.
Lords, the Venkatesh Dalwai, my lords, but Sanadalli Dalwai Venkatesh antane bartade. That's how they print.
It sounds like the passport name where they put your surname first and then the second
Yes,
name later.
yes.
First name later. Venkatesh Dalwai for petitioner learned additional SPP is directed to take the Jagdish is directed to take notice for respondent. So served with the copy.
Yes, my lord, I have.
He acknowledges the receipt of copy of the petition. Having heard learned counsel for the petitioner and having perused the complaint, is a fit case for grant of an interim order. Accordingly, there shall be stay of further investigation against the petitioner in crime number 0034 of 2025, registered by the Malpe Police Station, Udupi, pending on the file of Principal Senior Civil Judge CJM Udupi for the offences punishable under section 57, 191 within bracket 1, and 192 of BNS Bharatiya Nyaya Sanhita 23 till next date of hearing.
Great.
Piecemeal ಅಲ್ಲಿ ಬರ್ತಾ ಇದೆ.
Please allow.
Yes, Mr. Kiran Javli.
We are before this court questioning the rejection of the application to recall PW 15, 17, 18 and 19.
Office with order sheet ಕೊಡಿ.
Your Lordship, on the last occasion when the other matters had come, connected issues are all posted by Your Lordship on the 7th, wherein an application under 319 having been rejected, coupled with another matter, are now posted on Monday. In the meantime, this application was pending and I had made a mention on the last occasion that depending upon the order passed herein, the continuation of one of the proceedings therein would be sustainable or not would be decided. Now the learned judge has rejected this. The special prosecutor who has been appointed in this matter had made an application seeking to recall them, who are all these persons are all investigating officers who had not been examined with respect to the persons arrayed as an accused and has spoken to the contrary. Now, if he has spoken to the contrary, as a special prosecutor, he is required to justify that case to sustain the same. However, the learned judge records that if Your Lordship sees that order, it's more or less an order of passing an order of acquittal itself at this juncture. Particularly, Your Lordship would see page number 40, ink page 44, Your Lordship. And to me, in fact, this morning we moved it because he has posted it for recording of 313 in the afternoon today.
So what are those other criminal petitions which you had filed earlier?
One is 319, Your Lordship. The rejection of the application for the 319.
Four petitions are filed.
Please, all different issues, but all arising out of the same special CC.
Same crime.
The court sumoto makes persons as accused, and thereafter, when with respect to which there is no investigation, and the IOs have spoken contrary to it. In fact, Your Lordship could see page.
No, there is the reason, Mr. Senior Counsel, why I am asking is,
please,
the officers raised certain objections with regard to maintainability of this petition on the ground of several other petitions pending Are all those petitions arising out of the very same impugned order which?
No, Your Lordship.
No.
This has been passed just yesterday.
It is not the same impugned order. And please note that there is an issue with respect to petitioner is asking to treat certain witnesses to be a hostile witness and permit them to cross-examine.
And to examine them.
And to cross-examine them.
Cross-examine them.
Initially, they moved an application even before examination that these people should be permitted, especially police officers, my lord, they have to be permitted to cross-examine even before examining. The court rejected it on the ground that the special
319
application, on the ground that the special public prosecutor who filed the petition did not have a competency to file this petition because no authorization for him to file the petition. Subsequently, the petitioner filed another petition asking the same prayer that is pending before this court. And this petition has been filed subsequent to asking recall of certain witnesses who have been examined as prosecution witnesses. According to them, they have turned hostile. The court has gone into the material and says that they have not turned hostile. They have spoken to the records. They are investigation officers, a police officer. They have spoken to the records available during the course of investigation. Their contention, my lord, is that entire case has to be, the investigation itself is flawed. Investigation should have been done against XYZ. They have not done. In order to help them, they have not investigated properly. Therefore, I have to treat them as hostile. That, with great respect to senior friend, my lord, that I don't think so. That is.
The prosecutor is required to put his case properly. He is to put, and the court is required to see that. And if so, subject to the whatever is being done, it's even assuming for a moment this application had been allowed. It is not necessarily that the learned judge would have accepted the deposition or whatever he had said in the course of arguments. Why pre-close the bringing of material on record?
No, the application is under 311.
311.
Page number 45, my lord. Your lordship may see.
108.
Page 45, para 15, my lord.
Page number
45.
That's the order you mean.
Order, impugned order, my lord. Para 19.
No, the application seeking recall of PW2, PW15, PW17.
No, Your Lordship. Your Lordship may go to page 108.
108?
108. Ink page 108. I'm sorry. I'm sorry. My apologies. It is at page 103, Your Lordship.
That's an application.
Application. And my reasons have been set out at page 105.
So 15, 17, 18 and 19.
Please, Your
15, 17, 18 and 19. This is IA number kottillo, So when is the order passed on these now?
This is it commences.
Order passed on 29th March 2025. Page 22.
20.
Page 22.
22.
The PW2 ಬೇರೆ ಸೇರಿಸಿದ್ದಾರೆ ಇದರಲ್ಲಿ. PW2 ಇಲ್ಲ. Recall of PW2 Jayamma 15. Not Panna 17 Raju 18 Venugopal 19 Mallappa. So there is an inclusion of PW2 in the order.
Yeah, for the reason that why we wanted PW2 to get marked the 65B certificate with respect to the call details. Even that has been rejected.
No, but that's not your application. You filed separate one more
Yes,
application.
Your Lord. That is at page 96.
96.
96. But however, a common order has been passed.
Page 96.
All right, doesn't matter. All right. So all of them were sought to be recalled.
Please.
And all of them had given evidence.
Please.
So this application of yours is rejected.
Please, Your Lord.
Application of the state.
So prosecution's application comes to be rejected. Where is that operative portion of the order?
Operative portion, my lord, is at
Page
74, my lord.
74 is dismissed, are dismissed.
In fact, the discussion, my lord, is at page 45.
45.
Para 19.
So you're appearing for the accused.
He is appearing for complainant.
No, I am appearing for the complainant, de facto complainant.
State.
So you're interested.
State itself is the prosecutor.
Correct. So
And a special prosecutor has been appointed.
Correct. So your case is now prosecuted by this state.
They are the special prosecutor files it there, and it's not brought up in its logic conclusion. Consequently, I as the complainant am approaching this court.
All right, 45. Yes, what is your contention now?
My contention here is by permitting them to be recalled, it would have assisted the court to come to the conclusion. Why pre-close it? Even before hearing it. And in fact, your lordship may see in the impugned order, and more particularly on page 44, your lord, ink page 44, internal page 73 of the impugned order.
Internal page?
Internal page 73, para 35.
Ink page 73.
Ink page 44, your lordship.
44.
Internal page 23.
23. Okay. Yes.
Para
Page
18.
Para?
18.
Para 35.
35. Para
Of the
35 is
impugned
not-
order.
No. What is the internal page of the order?
That's 94.
73, your
73. Page 94.
Typed copy 73.
That's page 94.
94 ಇದು 44 ಅಂತ ಓದ್ತಾ ಇದ್ದೇನೆ.
ನನಗೂ
Page 90.
ಯಾರು ಅದು ಬರ್ದಿರೋದು? All right. Yes, internal page 73, page para 35.
In the above judgment, it has been speculated that the application seeking for shall contain the details as to why the witnesses are to be recalled, and recalling of witnesses should not be permitted at the fag end of the trial. When the aforesaid aspects are juxtaposed to the fact of the case, it would indicate that there are no materials to indicate the necessity of recalling the witnesses. As already discussed, the recalling by PW2 would also not arise for the reason that she was not the author of the video in which the statement was given. Nowhere it has been mentioned that the video was recorded, in which instrument it was recorded, or the person who recorded the same was mentioned. In the absence of any such material, the contention of the prosecution cannot be accepted. I answer point number 1. This is the order.
In fact, your lordship may see that order.
And then as a consequence, everything else goes.
Like page internal, page number 45, my lord, your lordship may see para 19, 20 and 21.
Page 45 andre internal.
Page 24, your lord.
24, my lord. Printed page 24, ink page 45.
Yes, para 19.
Para 19, my lord. The learned special public prosecutor during the course of his argument has urged that for the purpose of fair trial and
Has argued.
Argued that for the purpose of fair trial and to bring out the truth fact of the case, the recall of aforesaid witnesses, that is investigation officer PW 15, Shivanna PW 17, HS Raju PW 18, M Venugopal PW 19, Mallappa Shivappa Kavalapur is required. I have bestowed my anxious reading to the same. PW 15 so also ASA at the Paper Town police station had deposed that he was deputed to trace the accused persons, and accordingly he has traced the accused. It is relevant to note that the chief examination was conducted by then learned special public prosecutor, and he has not treated the witnesses as hostile. In fact, his report of arrest of accused number 16 so on was marked as exhibit P31, and he was subjected to thrilling cross-examination by the learned counsel for the accused. In the present application, which has been filed by the learned special SPP, no averments are made to indicate necessary of recalling PW 15 Shivanna. Just because he is an investigation officer, that does not entitle the prosecution to seek recall him for the purpose of further examination. I have bestowed my anxious reading to the evidence of PW 16 so on so. At that point of time, he was deputed by the station in charge to visit the Bengaluru to get statement of victim/injured Jayamma recorded. He has clearly deposed that when he had visited Manipal Hospital, she was not in a position to give her statement and she was unconscious. As such, he had filed a report as per exhibit P32, and even he was not treated as hostile. In short, the role of aforesaid investigation officer was very much limited, and now they are sought to be recalled by assigning no reasons and rather be bald allegations is level that they are deposing against the tenor of the prosecution case. with respect to PW 17 so and so is deposed of working as a police sub-inspector at Papertown Police Station, Bhadravati, and he has deposed in receiving written information on 23/5/2010 at about 1:45 a.m. And on the basis of the same, he had registered a FIR in crime number so and so as per Exhibit P33, and the complaint was as per Exhibit P1. He has deposed about conducting mother as per Exhibit P2 and also recording the statement and conducting of investigation. It is relevant to mention that during the course of his evidence, an application came to be filed by then Special Public Prosecutor under Section 154 of Indian Evidence Act, requesting the court to permit him to put leading questions. And since the said application was seriously objected by the other side, a detailed hearing was conducted on that aspect, and an order came to be passed by this court on 27/2024. In the said order, this court had successfully discussed the provisions under which a witness can be put to cross-examination. So he examined all these things and then passed a detailed order. It is not that he passed an order without looking into any of this material. And their role and the limitation in which they are given evidence. Unless they show, my lord, it's something contrary is given evidence, because these are official witnesses.
Your Lord.
ನಿಮ್ ಪರವಾಗನೇ ಹೇಳಿದಾರಲ್ಲ.
No, Your Lordship. That's the intent. Your Lordship may see my application at page 105, the relevant paragraph of my application. Your Lordship, in this case, additional accused came to be done. Those persons have never been investigated. In fact, 173(8) with respect to that ought to have been done, but even that they have not done. At the behest of the court, 319 came to be filed and they have been arraigned as an accused. Now, if they have not been investigated at all, and these investigating officers never had an opportunity to look into that aspect of the matter, should I not recall them and put questions? And they were named in the complaint. Who? These accused persons. Yet nothing was done. So we are only showing him the relevant documents which were part of the records and bringing it on record. What would be of value, whether it should be accepted or not, would be at a later stage. Why prejudge the issue, Your Lordship? It would have the same conclusion may be arrived at the later stage. In fact, Your Lordship, what I wanted to say is at page 105, para 3 of my.
Yes.
It is submitted that the above case was earlier represented by Special Public Prosecutor and has been resigned from his services, and the case now conducted by Public Prosecutor. It is submitted that the present special had been appointed in the above case on going through the material evidence examined by the causeway. It prima facie discloses that the investigation officers, especially 15, 17, 18, 19, have deposed before the court against the prosecution documents and materials which clearly show to derail the case of the prosecution, and the aforesaid so and so have deposed the same would be demonstrated by treating these witnesses as hostile and permit the Special Public Prosecutor to cross-examine. It is submitted that the affidavit have deposed which is not in consonance with the statement, evidence of the material witnesses of the prosecution. As such, the prosecution seeks permission of those to treat the above witnesses as hostile and permit the prosecution to cross-examine these witnesses to bring out the truth, which is just and necessary for a proper adjudication of the case and justice. It is submitted that the above witnesses to derail the case of the prosecution are deposed, and that if they are allowed to cross-examine, the truth of the matter would come out.
Who are the additional accused? Who are the additional accused?
The additional accused are the persons who had been named in the complaint as persons who had aided in the commission of the offence, aided and assaulted in the commission of the offence, and registered a case under 307.
So they are brought by virtue of an application under 319.
319 by the court, suo moto.
Not by the prosecution.
Not by the prosecution. So they were never examined. In fact, once that had happened, the natural corollary was.
You mean to say the prosecution has not led evidence on against those additional?
Yes,
accused?
Absolutely.
So that's why you want to recall these witnesses.
Yes, yes.
So they have not stated anything about the.
They only stick to what has been on record. This subsequent issues coming up, material being on record, how do we put it across?
No, all these witnesses have been examined post 319 application being disposed of.
No, what he says is.
That's correct, Mr.
What his argument is that the prosecution has not stated any material statement or anything with regard to those accused who are
When
subsequent.
the 173 was filed.
That's correct, my lord. I'm not on that.
So if that is the case, then they have to be recalled and to speak about the other accused.
If I'm correct, my lord, I'm subject to correction, my lord. And I think these people have been examined post.
No, your lordship, nothing. I'm instructed that
post.
nothing has been done. Correct?
If they are examined post, then they would have stated about the accused.
No, they cannot. That
Post
issue, they
post
cannot.
the
Because
31 post the 319, they would be accused inadmissible. Pre the 319, if the investigating officers then, before filing the 173, had recorded some statement, positive, negative, or whatever it is, that would have been on record. Even that is not there.
No, they should have
Then
given,
one,
they should have given a
and they were
deposition.
never been called for investigation.
In fact, as a public servant, they cannot speak contrary to the record.
We are not saying anything contrary to the record.
You stick on to record.
Yeah.
Correct.
He is not expecting you to say anything beyond
contrary.
record.
Correct.
Now what he says is, if pre-319, when those accused were not brought on record, if certain statements are made, and after 319, if some statements are not made, then they will have to make, because after 319 is the one which is going to be
Correct, ma'am.
relevant.
I have no dispute, my lord. I'm not sure, my lord, if these witnesses have been examined post 319 or pre 319.
Post 319, they can't be done. They become accused. How can I examine those persons?
Not those persons.
Accused persons, your lordship.
Not accused
Courts,
persons. Not those persons.
These persons,
the PW with
15,
even if
17,
they have,
18, 19.
your lordship, even if they have been done post 319, if they have not been put on questions or rather confronted with material which was not in existence, which would have to be brought out on record by the special prosecutor, and if that had not been done, would it not be blocking the evidence, your lordship?
See, it cannot be done because they are not accused by them.
Yeah.
Because only post 319 they become accused. So
Correct.
post 319 they should have been examined, and if they have not stated so, they are required to be brought.
PW 15, 17, 18, 19. The question, my lord, is these four witnesses have been examined before 319 or after 319?
After 319. After
They are
319.
examined after 319.
Correct.
That is not in dispute.
If they have not spoken about these
Additional accused.
Then they have to be recalled to speak about them. Only then there is some material.
Then some material comes.
Point, my lord, these witnesses was examined post 319 accused came into record. Therefore, they were there. It is not that things happened thereafter.
Is it going to be contended by the state that if the material available on record by the honorable prosecutor was not brought on record should go to the benefit?
No, I'm only saying that.
Then let it be fair. Let it be fair.
What he says is the trial court order is justified for the reason that all materials which are there available against the additional accused are already stated by these witnesses whom you are now seeking to recall again.
There's no fun for the prosecutor to recall witnesses. No fun.
No, they should have given a depositions of these witnesses. The date would have informed us when they have done it.
What is the stage of the process?
The 313 is recording, your lordship. I don't know at this time whether he has concluded it also. He had posted it at 2 o'clock. In fact, we filed a memo to the court saying that we have moved the court this morning. I don't know what has happened.
I listed tomorrow, then get the details, get the evidence also. Let him also see whether any material anything has been already stated by way of evidence by these witnesses.
In fact, your lordship, this would be connected with the Monday matter. So your lordship may just give us interim orders till Monday and list it along with all the three cases.
Charges are framed. What's the point now?
Not charges, sir. 313 state. Poster. Then it has to go for evidence. Evidence of the defense if they so desire, and arguments.
Statement of the accused.
That's all. That's all. That is all I want to be on. So let it be there. So we should say till only Monday. Then all the connected cases would also be there for this court to take it as an omnibus scenario. Or status quo to be maintained.
Status quo, the civil case.
Whatever it is, the stage at whichever it is today, let it continue.
Defer the proceeding.
Defer the proceedings. That's all.
We'll say not to precipitate the matter till Monday.
Lordship may
Please.
defer the proceedings.
That's all.
Defer the proceedings.
Not to precipitate it and defer the matter till Monday.
Yes, please.
Heard. Senior Counsel Shri Kiran S. Javli on behalf of Kattimani Pooja Manohar for the
sequence of
petitioner.
319 ಯಾವಾಗ ಆಯ್ತು?
Learned additional SPP.
Synopsis.
C. Jagdish is directed to take notice.
I take notice for R1 man.
R1. Who are the others?
R2 is to be
R2 to
accused
6,
person.
they should serve a notice.
R2 to 6 are
Accused man.
Accused persons.
2 to
Accused 1 to 5.
2 to 6.
notice to R2 to 6.
Counsel may be permitted to be served.
Learned counsel for the petitioner is also permitted to take out notice to the counsels representing the respondents 2 to 6 before the trial court.
Please.
Special court.
Special court.
Sessions court.
Special court.
Special court for MP.
Special court. Full stop.
matter may be deferred.
In view of the fact that the matter before the special court is now set on for recording of 313 statement, the special court is directed not to precipitate the matter and defer the proceedings till Monday.
8th, 7th is coming up. Your lordship may give it 8th.
7th.
Till next date of hearing.
8th to go to
Till next
7th.
date of hearing. Call this matter on 7th.
Please. Grateful.
You secure the evidence.
Yes.
If they have already stated, then it will not.
So they probably they might not have, because they can only speak for what investigation they have done. If there is no investigation done with respect to these additional accused people, they will not be able to say.
Correct.
And they cannot say also.
Correct. So now the point of making these accused.
No, they will have to be brought on record by
One is after 319.
Correct, man.
When they come on record as accused, the investigating agency will have to investigate.
Further, actually 173, 8 should have followed.
And secure material.
No, that they have to seek for prayer. Trial court cannot do that. They have to come before this court. And
The
seek
learned
for-
prosecutor then has not done it.
No, it is the duty of the prosecutor that once the additional accused are added, then there has to be, they have to be
Investigation.
investigated, fresh material has to be secured. Then based on those material, they'll have to speak about them.
That's those people who conducted investigation with respect to those accused has to speak. You can't ask these people to speak on that.
Whosoever.
Correct, man.
There has to be some material against them.
Correct, man.
On record.
Correct.
Merely making them accused is not going to establish
Please.
any case against them.
But
I don't know, prima facie.
Say, absolutely, Your Lordship. That is what follows.
They wanted to bring out their case through these investigation officer and say that that's probably.
What is the offense?
302, if I'm correct.
In offense, you know?
307, attempt to
307.
murder.
All.
It's a government official.
So you're sure about this application not being agitated earlier at any point?
No, that was rejected earlier on the ground that the prosecutor has got no role to present it before the High Court. Locus standi, it has been rejected.
So the
On that score, it has been.
issue of maintainability is kept open.
And
till
that is
next date of-
before examination.
Before.
In fact, that is before examination.
I think Mr. Shyam Sundar was there at that time. It was rejected.
Yes, I have kept it open till Monday. so
Please,
that-
Your Lordship,
That day
please.
this can be.
Please.
Yes.
List number 3, serial number 12, my lord. Interim order.
Serial number 12 interim order ಬೇಕಾ?
Interim order ಇದೆ ಸ್ವಾಮಿ extension.
Extend ಆಗ್ಬೇಕಾ?
ಹೌದು.
Serial number 12 interim order extended till next date of hearing. All these are referred
Please, your
to
lordship.
Lok Adalat.
Please, your lordship.
Anything else?
Much obliged.
ಇವತ್ತು ನಂಬರ್ ಹಾಕಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಟೋಟಲಿ ಆರ್ ರೆಫರ್ಡ್ ಬಟ್ ಲಿಸ್ಟಲ್ಲಿ ಎಷ್ಟಿತ್ತು ಔಟ್ ಆಫ್ ದಿಟ್ ಸಮ್ ಆಫ್ ದಮ್ ಆರ್ ನಾಟ್ ರೆಫರ್ಡ್ 46 ಇವರು supposed to post MVC matters. They have listed all RPFCs. So tomorrow, I think some 150 to 100 matters will come. Yes, Mr. Huh? Second list. ಮೈಕಲ್ಲಿ ಏಕೆ ಹೇಳ್ತಾ ಇಲ್ಲ ನೀವು? ಮೈಕಲ್ಲಿ ಮೈಕ್ ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ. ಹಾ, ಏನ್ ಹೇಳ್ಬೇಕು? ಏನ್ ಬೇಕು? ಹಾ,
ಹಿಯರಿಂಗ್ ಡೇಟ್
ಯಾವ್ದ್ರಲ್ಲಿ?
16 ನಲ್ಲಿ.
ಯಾವ 16?
ಥರ್ಡ್ ಲಿಸ್ಟ್ 16th. 16
ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲ,
ಸದಾಶಿವಪ್ಪ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಈ ಸ್ವಾಮಿ, ಮಿಸ್ಟರ್ ಕೌನ್ಸಿಲ್, ಲಿಸ್ಟ್ 1, ಲಿಸ್ಟ್ 2, ಲಿಸ್ಟ್ 3 ಇದೆ.
ಥರ್ಡ್ ಲಿಸ್ಟ್.
ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹೆಸರೇನು?
ಸದಾಶಿವಪ್ಪ.
RS ಹೆಗಡೆ ಇದೆ. R16
ಸದಾಶಿವಪ್ಪ.
ಎಲ್ಲಿ ಹುಡುಕ್ಬೇಕು ಇವಾಗ ಸದಾಶಿವಪ್ಪನ? RB ಸದಾಶಿವಪ್ಪ. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್. ಏನ್ ಬೇಕು ಇವಾಗ?
ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹಿಯರಿಂಗ್.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲ, ಇದೆಲ್ಲ ಲೋಕ ಅದಾಲತ್ ಕಳಿಸಿದೀವಿ. ಇದ 16th 16.
ಥ್ಯಾಂಕ್ ಯು.
ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ಬೇಕು ನೀವು. ಯಾಕೆ ಇಷ್ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಹುಡುಕ್ತಿವಿ. RS ಹೆಗಡೆ ಅಂತಾರೆ ಅವರು ಮೇಡಮ್ ಪೆಟಿಷನರ್. 16th ಬನ್ನಿ. ಇದು ರೆಕ್ಟಿಫೈ ಮಾಡಿ ಮಾಡಿದ್ರ? ವೈ ಇಟ್ ವಾಸ್ ಕಮಿಂಗ್ ಸಮಥಿಂಗ್ ಇನ್ ನ್ಯೂ ಸಾಫ್ಟ್ವೇರ್? ಮುಂಚೆ ಏನಿತ್ತು? ಇದು ಮ್ಯಾನುವಲ್ ಬರಬೇಕಾ? ಏನೇನೋ ಆಗ್ಬಿಟ್ಟು ನಾವು ಹುಡುಕ್ತಾ ಇದ್ದೀವಿ.